Like that mentioning, do it tomorrow. Thursday we'll see. Next.
Your Lordship, may I be permitted to mention one matter? Your Lordship,
Give the mention, send the mentioning slip.
Your Lordship, the junior is there with the mentioning slip.
So
Advocate
the junior
Shrutapa
will be
Singh Paul.
mentioning, another will be mentioning virtually.
No, Your
We
Lordship,
mention
junior is
over
there.
here.
I'm only mentioning, Your Lordship, for extension, Your Lordship. This in Shrutapa Singh Paul is there for with the mentioning slip, Your Lordship.
Chalo. Give it.
For the statement.
Number one, I am for the appeal lordship.
Yes. Paperbook ready. So tomorrow do the matter. Day after tomorrow.
Is the last day, so tomorrow, and my lord can. Easy matter, very simple.
Yes.
Day after tomorrow.
There was a
Paper book is ready.
paper book, sorry.
Service done.
Service done, my lord.
Report is there.
Report, no, my lord, only I have the copy where the
Achha, the
signature of the.
The communication, pursuant to the communication on May 8 by the Inspector in charge, Bhoktinagar Police Station. The appellant is represented by learned and advocate. Full stop. Since the appeal is ready for hearing, list the appeal on 19th June 2025 under the heading hearing.
Yes.
Yes, have you appeared?
Yes, on instruction, we appeared before the court,
Then what happened? He's been allowed.
Yes, the order complied with the
He's been allowed to continue on the same bail and bond.
that instruction allowed to apply for the certified copy.
No, what is your instruction?
Instruction is that he has appeared and not the compliance of the order has been done with that.
Learned advocate appearing for the petitioner submits that he has complied with he has instructions that the petitioner has complied with the directions passed on 11/6/2025. None appears on behalf of the state. In view of the limited issue on which the revisional application was preferred, further pendency of the revisional application is unwarranted. Accordingly, CRR 463 of 2024 is disposed of. Yes, yeah. Never done. Never done in High Court. Take out certified copy. Huh? Take out certified copy. Don't save the money of certified copy. The matter the application for bill was mentioned for the spot after the order having been passed. The submissions advanced in support of such inclusion do not require any consideration of the spot. Accordingly, let the matter go out of list as the same is a disposed of application.
After the state, my lord. Direction given to the complaint and the same bill, my lord.
Yes.
Compliance done, my lord.
Compliance done.
Compliance done.
Communication is
Communication.
learned advocate 8 appearing for the state submits that there has been in compliance. communication to that effect has been submitted by the learned advocate appearing on behalf of the state. In view of the limited issue on which the revisional application was preferred before the court and the same being complied with, I am of the opinion that further pendency of the revisional application is unwarranted. Accordingly, CRR 234 of 2025 is disposed of. Server copies next.
Lordship.
Yes, sir.
Why?
Lordship, it was a case where the Lordship called for a report. In the FIR, in the FIR from the sixth
was
line,
no-
last bottom 6 lines,
Four stitches were
4
there.
stitches were there. The report is here, Lordship.
No medical report.
No, only OPD. Further MRI was not done.
No, 4 stitches were done or no?
Uh,
Pretty.
yeah. Though the formal injury report from Balarampur PHC is yet to be provided, prima facie evidence reveals that the complainant sustained head injuries necessitating 4 stitches and prescribed medical attention corroborates the occurrence of the assault. Huh? Here in the OPD ticket there is 4 stitches. Report and here.
Yes.
Statement of the victim has been recorded in page number 9.
Design. Where is the stitches in the medical OPD?
OPD second line. Lordship.
No.
Page number
Yes,
4,
yes, yes.
4 stitches.
This only the lady I am allowing, rest I am rejecting.
Much obliged.
Learned advocate aid appearing in for the petitioner submit that the petitioner the innocent and has been falsely implicated in the incident case on the grounds of previous rivalry. The incident as complained of are baseless and the petitioner as being innocent of the charge is should be favored with an order of anticipatory bail. Next, learned advocate for the state has produced the case diary as also the injury report along with the report so called for today. Full stop. The report reflect the 4 stitches were administered on the victim oblique injured who was assaulted at the behest of the petitioners. The statement of the injured also reflects name of the victim and name of all the accused persons. Having considered the gravity of the offense, I am of the opinion prima facie a case made out. However, police, and however, petition number 3, Bailey BBB being a lady. Her she's allowed her application for anticipatory bail is allowed. So far as the petition number 1 and 2, Riyaj Hussain and Rijak Hussain are concerned, their application for bail is rejected. Accordingly, CRMA number 358 of 2025 is partly allowed. Reports are submitted, we kept with the record. Oh, যেটা ordinarily দেন না 438(2) are born to the arresting officer, ওটা petition number 1 at 10,000. With two sureties of like amount each, one of whom must be local arresting officer, are 438(2), 480(2) করে দেবেন।
Number 6.
এটা বললাম লাস্ট এদিকে উপরে দিয়ে দিকে সিডিটা দেবে, এটা কালকে বললাম না লাস্ট এদিকে ফর অর্ডার্সটা এখন যদি ডিকটেশন দিতে আরম্ভ করি কতক্ষণ লাগবে। Come at 4 p.m. I'll dictate the order. So if I start dictating the order now, whole of the list would be jeopardized.
Number 7. Yes, 7 months, the 11 days of physical action. I think, learn from case.
Yes.
On last, also, for the state to produce the.
My lord, this is the CFSL report.
After 2019. The arrest was effected from a railway station. No ground of arrest was disclosed in the course of arrest. And in this regard, the Lord selection has to maybe continue to rely on that part of the Honorable Supreme Court.
In NDPS case,
No, madam, if the arrest is awarded by the Honorable Court, the same will be ground of land bail. Even if there will be restrictions of on the ground bail exist. Bihan Kumar.
Bihan.
it's an IPC offense.
But this is IPC offense, but there is observation part of the Honorable Supreme Court.
Then
That
এই
may-
আমার টেবিলে দুটো জাজমেন্ট আছে, সাদা কাগজ নিয়ে এসো তো।
IPC offense, but that case, your law restriction. There is an observable Honorable Supreme Court, if there is a statutory restriction, then also that will be a ground for bail. Okay, see, Raja was recovered, one of the accused persons was bail. Charge sheet filed.
Learned advocate appearing for the petitioner submits that. Learned advocate aid for the state at the inception submits the FSAL report which reflects that the FSL report opines that the seizure so effected was in respect of the contraband being ganja. I tetrahydro cannabinol. এইখানটা দেখে নেবেন কোথায় আছে। Full stop. Records reflect that commercial quantity of contraband was recovered from the possession of the petitioner, being 62.75 kgs, and the present petitioner. You are the sole accused.
There is other accused. One of the accused who from whom no recovery was made was enlarged on Shilpadam.
And the petitioner has been in charge sheet বলে দিয়েছি?
Short
And the
submitted.
petitioner has been implicated in the charge sheet. Full stop. The investigating learned aid advocate submits that the petitioner is innocent of the charges, and in spite of the same, he has been arrested without supplying the grounds of arrest, and as such, there has been non-compliance of the judgment of Vihan Kumar versus State of Haryana. Full stop. Learned advocate aid for the state opposite is the prayer for bail, and submits that since the petitioner, since the seizure was effected from the possession of the petitioner, and the seizing officer informed the petitioner prior to his arrest. So far as the offense is concerned, the petitioner is unable to overcome the rigors of section 37 of the NDPS Act. And as such, his bail should be rejected. In view of the judgment end of the Honorable Supreme Court passed in Gyan Kumar, as has been invited it to be dealt with it by the learned aid advocate appearing for the petitioner, Gyan Kumar Supra করে দেবেন. This court is of the opinion that that the said judgment do not cover offences under the NDPS Act, since an earlier judgment of the Honorable Supreme Court, being Narayana Swamy Ravi Shankar versus Assistant Director, Directorate of Revenue Intelligence, reported in 2002 8 SCE 7, which is a larger range judgment, had dealt with the issue. Paragraph 6 of the judgment refers as follows. Paragraph 6 of the judgment refers as follows. Subsequently, the Calcutta High Court had elaborately dealt with the issue in a series of judgments, being CRM NDPS 169 of 2025, by relying upon the aforesaid judgment of the larger bench in Narayana Swamy Ravi Shankar's case, Ravi Shankar Supra, and Superintendent NCBE Chennai Supra, and arrived at a finding that the ground of arrest being not communicated to the petitioner cannot be the sole issue of releasing the petitioner on bail. Consequently, the prayer for bail of the petitioner is rejected. CRM NDPS 203 of 2025 is dismissed.
Direction very possible.
As a charge sheet, it has already been submitted. The trial court would take steps for proceeding with the next stage of consideration of charges within a reasonable period of time, and would also take and also put in efforts for taking the trial to its logical conclusion. Chalo, next. Yes, FSL report.
I have not done it. I have followed 10, my lord.
Lordship, they have stipulated both the copies here. It has been collected, Lordship.
Just 1 minute, sir.
The original is there and the photocopy is with me.
You got the original report now? Keep it with.
That is the original, Lordship. This is the photocopy.
Is the original?
Lordship. No. Yes, Lordship, they has the original. I pardon, Lordship, my mistake.
Yes, sir.
I was not on the ground, but I could just follow them, you know, the name of the passport. I don't need how to not
Page
I don't page 50. 1
1 5. Yes.
I would try and follow them, you know, that's the witness here.
Ah.
Now my time comes page 20 of that. So it's the calculation which I'm checking. Thank you.
Yes.
Now, this person never thought of, you know, witness is there, other this game is not of them.
Is your relation. Why should they, whatever it is your person. That is, this is the,
My person, might not say that they will be family members informed to concern PS. But that it is.
signature of the witness, either a member of the family or a respectable person of the locality. It is yes, I. So if you agree by that, you bring him as a witness, sir. Whom prosecution will cite as a witness is an exclusive prerogative of the prosecution. Neither the court can direct that, nor any other person can direct.
Here, my lord, stop witness, my lord, will sign here.
That is something else. If you want to prove that, you have got to disprove by way of defense evidence. But as a court of law, I cannot dictate him whom to cite as a witness. Chole asho. How many days? How many days?
My lord, I have been charged for 8 months. But charge sheet has been completed, my lord, 16 witnesses, my lord. My lord, the interim pay, my lord, so, since the condition, my lord.
Renew your prayer for bail after the constitution of charges, sir. Acha. Pursuant to the direction passed on 11th of June 2025, the a report along with the forwarding letter has been the FSS report along with the forwarding report has been submitted on behalf of the state. Let the same be kept with the record. Since the FSS report has been collected, supplementary file or no?
Today he'll.
Acha. The investigating officer would file is supplementary report, supplementary charge sheet at the earliest. Learned trial court on receipt, learned trial court have been supplied with the copies or no? Learned a trial court would within a month from the supplementary charge sheet having been filed with supply the necessary documents on which the prosecution intends to rely upon for approving its case. Acha. Learned trial court would also put in efforts so that within 30 days hence from the date of supply of the copies, the stage of consideration of charges are over. Petitioner would be at liberty to approach to renew the prayer for bail after the stage of consideration of charges is over. Post up since commercial quantity of contraband was recovered from the possession of the petitioner. I'm not inclined to enlarge the petitioner on bail at this stage according to CRM NDPS 209 of 2025.
Deeply obliged.
I'm keeping that, I'm not agitating that point. You can take it.
Deeply obliged.
For the statement.
Hello, petitioner is not there.
Well,
When are you going to submit the charge sheet?
Lordship submitted charge sheet on 31st May 25. And Lordship, he is the previous antecedent, and not only that, this present petition is attracted in the 154, but he has been shown arrest in 153. And he is doing a joint venture ganja business, and every one statement is there, your Lordship. The habitual and just
Charge sheet submitted.
charge sheet submitted.
Page 30, the contraband was seized from one Prabhat Chandra Borg. The case of the prosecution is that this petitioner was apprehended in connection with another case, where he made statement that some contrabands are in the house of Procedural. And Procedural was, the house was raided, Procedural was arrested, contraband was seized. And this case started. Now what you can see is, page number 11, page number 7 of my petition, a schoner sprayer was given before the court, which was allowed on the next day, that is page number 8, Lordship. And this petitioner was booked in this case, and he was taken in PC, but no further recovery, nothing regarding him. In this present case, Lordship, nothing has been recovered from the petitioner. It was recovered from the house of another person,
Yes.
that is Prabhat Chandra Burman. Charge sheet will be submitted, Lordship.
Yes, my lord, 161 statements. And
27.9 kilos of gaja from the house of Prabhat Chandra Burman.
They are. They are kept in one room and thereafter sold it in high price, stated by the neighbor, adjacent neighbor. So those are the involved in this business unit. And
In this case, any recovery from him?
No, Lord.
no, but other cases recovery.
Other, how many cases?
One case, only one
more
case.
So you have split up one case into two cases.
That is the thing.
The hobby, though.
And Schoner said we
Joint
in that
venture
case also.
business is- Joint
Could have-
venture
Could have
business
made
is-
that a continuation of.
Continuation of that case, that should be. New case started and shouldn't be arrested in the other case also.
27.9 kgs.
Lordship, from another person.
Learned advocate appearing for the petitioner submits that there has been no recovery from the petitioner in connection with the instant case. And he was shown arrested by the police authority is on the by the police authorities on the basis of a statement end of co-accused. Full stop. It has also been submitted that the investigating agency on conclusion of investigation has already submitted a charge sheet before the jurisdictional court. Full stop. Learned advocate for the state submits that the petitioner do not have a clean antecedent and is already is already arraigned in another case of the same police station. Full stop. I've considered the submissions of the learned advocate appearing for the state and the fact that there are two cases, Shaimganj Police Station case number 154 of 2025 and Shaimganj Police Station case number
154.
150.
153.
153, this one, 153.
Previous 153, my lord.
Shaimganj Police Station case number 153 of 2025. Full stop. Having regard to the genesis of both the cases, I am of the view that the same are intrinsically connected to one another. And there has been no seizure from the petitioner in connection with the instant case, while there was a the seizure in connection from the petitioner in connection with Shaimganj PS case number 153 of 2025. Having considered that the complicity of the petitioner is restricted only to the statement of co-accused and the charge sheet having been submitted, I am of the opinion that further detention of the petitioner is unwarranted in connection with the instant case. Accordingly, the prayer for bail of the petitioner is allowed. Petitioner shall furnish bond of rupees bond of rupees 20,000 with two sureties of like amount, each one of whom must be local to the satisfaction of the learned special court. If on bail, the petitioner shall the local surety in this case would be of an individual who would furnish the title deed of property and would stay within the jurisdiction and would stay within the jurisdiction of which we have the jurisdiction of the learned special learned additional session judge, first court, NDPS Act, which we have. Full stop. The petitioner shall on each and every day be physically present before the learned aid trial court and will not hinder the progress of the trial in case of any non-compliance. The learned special court would be at liberty to cancel the bid without further evidence.
Deep leverage.
CRM NDPS number 239/2025. So, yeah. Disposal. Allowed legal property disposal. Next. Allowed. Hello.
26 kg 100 gram, 26 kg 100 gram, 2 person, my lord, 103 just in custody, my lord, charge sheet not submitted.
Charge sheet not submitted, my lord. To kindly consider the age of the.
Submitted. Next circuit is easy.
Yes,
Next circuit and please.
next, sir.
Let the bail application be placed before the next available circuit bench.
Come on.
Next. Learned advocate appearing in for the petition do not intend to press the present bail application. Mr. Luxem, learned advocate appears on behalf of the state in view of the submissions who advanced. So, CRM NDPS 244 of 2025 is dismissed as not pressed. Next.
My lord, in this case, I am in custody since 162 days. Now, I am not named in FIR. One accused was arrested. From the leading statement of him, my house was raided, and so for the allegation is concerned, huge quantity of cough syrups were recovered. Actually, my lord, if your lordship, can you take the page?
From your house it is recovered. কি করা যাবে?
No, my lord, can you see? I am the medical distributor of a medicine company. Page number 13, can you
So
see?
you can introduce the documents.
I have already annexed, my lord.
আরে আমাকে দেখি কি আমি ইনভেস্টিগেটিং অফিসার নাকি?
Then, my lord, already I have supplied the copy, that is page number 13, and this is the earlier, this is the first certificate which was subsequently renewed up to 2026.
Your lordship, kindly seize the place of seizure and the address mentioned in the license.
Same Odlabari Bajar.
Odlabari Bajar.
Hmm.
And your house is at, I'm showing it.
Odlabari. It in the house.
এবার পুলিশ খেপে গেল কেন? অনেক দিনের ব্যবসা তো।
My lord,
পুলিশ খেপে গেল কেন?
my lord, actually,
হ্যাঁ? পুলিশ না জানে
Odlabari Bajar. Can you see the seizure list? Odlabari Bajar.
196 holding number.
My lord.
Your lordship.
Hmm.
Page 66, one second.
My lord, I have the certified copy. I can show your lordship. As per the leading statement of the another accused, my house was raided and Odlabari Bajar. If your lordship, can you take the certified copy of the seizure list?
Lordship, the seizure list we have from the possession of Sanjeev Sarkar, son of Sushil Sarkar of Odlabari Bajar, of
Odlabari
Odlabari Bajar, near Chowpati, PS Mal.
That is my license also says Odlabari Bajar.
Now, this is Messrs. New Life. His license is of the shop where he can keep it, not in his house. Is Messrs. New Life.
That is my, I'm a distributor. I have house come shop.
You cannot keep your articles, lordship knows better than me that the place where the license is issued, the contraband article has to be kept in that premises, not in other premises.
Now kindly see the license. Pharmacy on the premises is Odlabari, Post Manabari, PS Malbaya, district Jalpaiguri.
Post Manabari,
Manabari.
PS Malbazar.
So that is same thing, same area.
That has to be, lordship, specific instruction has to be taken regarding the same.
I have a license, valid license.
So you may have a valid license, but then how did this Muhammad Rohim come to know regarding? What is your relation with Muhammad Rohim?
Actually, I am the distributor.
Rohim is the
Rohim is
transporter person.
transporter person.
Trans-border.
No,
other
madam.
side, eh?
No, my lord. Actually, he took, so far his version, he took medicines from me.
And medicine, how he is a licensed vendor?
No, my lord.
ও জানলো কি ও কেন রেড করলো?
He was arrested.
আরে, he is arrested. But then how?
Page 38 and 47, statement of Mohammed Rahim. Lordship, as per section 62 of Drugs and Cosmetics Act, Lordship knows that
Sir, one thing is that Mr. Bhumi,
My lord.
when did you give it to the investigating officer?
My
This
lord,
particular document?
I have handed over
When handed over the.
at the time, at the time of seizure.
Where is
but-
the Caesar?
So they did not seize my license. They did not seize my license.
No, but first time you cannot come to High Court and take up this point. How many days you are in custody?
I am in custody, my lord, since 162 days.
So in any. Actually, এটা তো পুলিশের কাছে না গেলে ইনভেস্টিগেশন হবে, সেই ডিডব্লিউ তে গিয়ে দেখাতে হবে।
No, my lord, they did not seize my license. When I show them, they did not seize.
তো অন্য জায়গা থেকে সিজার হয়েছে।
No, my lord, from my house, seizure list says I have the certified copy of the seizure list.
the license is Mrs. New Life, the shop,
Huh.
where he has to keep it.
So that is Otlabari Bazaar. That is my house.
Your
also.
house is also where
Udlari
Udlari Bazaar, but
Bazaar.
you cannot keep your articles in the house because
Are
the
my-
license says New Life.
What you are saying,
সেইটা কনসেশন নয় দিয়ে দিতে পারলাম, কিন্তু নাথুরা শৈলাজ সিং স্টেটমেন্ট কোথায় আছে? নাথুরা
That is statement,
of the Caesar witnesses।
Caesar witness. Lordship, may I get back to
এটা
you?
একটু দিন তো।
There are two Caesars, so.
my lord, my house and my store is same.
But this is first time you are taking before High Court. Two witnesses are there.
Actually, I have to show my house and my storage. Then I will get the license.
Actually, little pass over, I'll just. I'm looking. The IO is not there, I version.
But it is not a case that I have illegally procured the same. I have the license to store this, have the storage.
But you have not given it to the police authorities.
They did not seize me, lord.
পোস্টে দিয়ে U26 হচ্ছে আর সিজ করলো না।
My lord,
হ্যাঁ?
actually, my lord, when I was arrested, I am a businessman. I was arrested. I have handed over my license. They thrown out the same and did not keep cognizance.
So now how have you got? Now how have you got it? Somebody was pursuing the case on behalf of the petitioner.
My lord, his family members,
They could have easily in these 5 months given that.
now my lord, that in the license it has been mentioned, the new life proprietor Sanjeev Sarkar, that is the petitioner. Being the bona fide person of to store those articles, he was arrested and in custody since the
Let's come
5
tomorrow,
months.
come to prepared, come to.
Lordship.
Ask your IO to be present.
Lordship.
May I hand it over a license to him for verification?
কিন্তু অনেকদিন লেগে যাবে।
Lordship,
Not
tomorrow.
today, come tomorrow, I'll consider this.
Tomorrow I'll go check it.
I'm grateful, your lord.
Lordship, may I take first, your Lordship, to page 9 of my petition? page 9 of my petition, the recovery portion, then I directed such and such and such. From where? I recovered one packet wrapped with black color cloth from the pocket of the detainee, such and such, Dinner place. I searched the vehicle but found nothing, but on personal body search, I recovered one packet. Now, Lordship, the personal body search, the search, seizure, arrest was done by an ASI. Now, here is the Lordship, the notices, certified copy of the notices upon both the accused persons. In this regard, Lordship, as per the notification of West Bengal government, number 1573, extraordinary, Lordship, I am handing over. It says that not below the rank of sub-inspector is authorized to take issue any notice under 50, and 42 is not there. Now, Lordship, here the judgment I am referring, the order of a coordinate bench, Lordship will find the bail was granted on this point. Subsequently, state preferred an cancellation, where the division bench observed that this case of the state was, in that case, the person was on his legs, or he was moving on his foot with a bag. So no question of 50 arises because the contraband was seized from the bag, and 43 is applicable,
Yes,
not
from the
43.
person concerned, yes. Into you have a notification.
Lordship, I have the notification is there, Lordship.
No. How is the ASI doing this?
Lordship, page 2, the notification is there in the judgment.
No, let me see.
Arun Tamam.
The ASI too.
No, please. Please, sir. Yes. Inspector in charge, not also present there, my lord.
But 50 can be carried out by ASI.
Lord, I'll take instruction.
Huh?
Lordship, in the order, the notification is there. And Lordship kindly sees page 9, last 4 paragraphs. Why the ASIs are stopped, Lordship? Lordship kindly sees
There
page
is a
9.
notice under section 50.
The certificate copy I've given. I've given this certificate copy. Yeah.
Huh?
I've given this certificate copy, Lordship.
Where in the
No, Lordship. Certificate copy I handed over. Left side. Here it is, Lordship.
this one?
This one. Both accused, 450 by ASI. Forward conferred under section 50.
You did not give any gazetted officer. Did
No.
you give? IC of the same police station.
Same police station.
Okay.
No gazetted officer. And Lordship kindly sees last 4 line of page 9. The contraband articles were taken from the PS and after that deposited in Malkana. Lordship, see, then with the seized articles having total 105 grams and left Dinata PS, and on returning Dinata PS kept the articles on Malkana. So
Ask your either produce a notification that ASI is authorized, or in the alternative, how have you done the search? Ask you, I have to explain yourself.
Lordship, it will
He is the investigating officer or what?
no, Lordship.
ASI, change করেছিস?
He was a complainant. That's all. Search, seizure, arrest, and then complaint.
Yes, I Lappa Shabde Sherpa now the IOD. Completed.
So who acted as a gazetted officer?
No one, Lordship. Lordship, see space 13, arrest memo. No gazetted officer present. Not even relatives or local witness signature is there.
Tomorrow,
Day after tomorrow, Monday.
ask your officer to be present.
Lordship.
You explain.
Direction can be given. Even I request him to appear and assist me when they turn up.
The inspector in charge, along with investigating officer of the case, is directed to be present in court. for assisting the learning aid advocate appearing on behalf of the state. List the bail application on 19th, on 19th of June 2025 under the same.
Highly obliged to you.
Next,
My lord, I am for the petition.
who is for the state? Yes.
My lord, total 28.300 kg gaja was recovered.
Other accused of
Accused on 9th June, your lordship was pleased to allow bail of another accused person.
Yes, Mr. Chakraborty.
My lord, 28.3, the commercial contract thing is that charge sheet has been filed.
আজ কি হবে কবিকার মামলা?
It's a case of 16th September 2024.
I am in custody for 275 days.
Caesar to the exit. Caesar is.
তো সিজার থাকলেও ঠিক আছে আর কি এই
Sir, আমার petition-
Learned advocate appearing for the petitioner submit that the petitioner was arrested on 16th of September 2024 and since then he is in custody. Accused persons,
My lord, Tanesh Kudri, sir.
other accused person who have been named in the charge sheet have already been released on bail. Either has been granted bail.
My lord,
Granted bail.
on 9th June.
Huh?
By your lordship.
By your.
এই কটা 31 পর্যন্ত দিয়ে দেবো 32 নেক্সট আর কি না 31 32 নেক্সট আছে
That I've already stated to the IO, the 30 is the limit now.
কি বললাম learned advocate for the state opposite is the prayer for appeal. However, having regard to the fact that similarly is situated accused has already been on bail and the petitioner is in custody is since for total 16th of September 2024. I am of the view that as per the detention of the petitioner is unwarranted in the fact of the case as charge sheet has already been submitted before the jurisdictional court. Accordingly, the petitioner is released on bail. Petitioner shall furnish bond of rupees 20,000 with two sureties of like amount each one of whom must be local to the satisfaction of the learned judge, bracket is special court under NDPS Act, bracket close, first court, Jalpaiguri. The local surety in this case would be of an individual who would furnish the title deed of property within the jurisdiction which would be situated within the jurisdiction of the learned aid special court. If on bail, the petitioner shall be physically present on each and every day of the on each and every day so fixed by the learned aid trial court and would not hinder the progress of the trial. In case of any non-compliance, the learned special court would be at liberty to cancel the bail without further. So the is court. Accordingly, CRM NDPS 249 of 2025 is allowed. Sir.
I am for the petitioner, my lord.
Who is for the state?
I am for the, just receive the CD, my lord. Tomorrow. CD. Tomorrow, my lord. Voluminous CD, just
Yes,
receive.
all right. Not today. কালকে ফাইলিং নাকি
Yes, sir.
yesterday filing
Just receive render.
exactly
No, Mr. Kumar, principal on
আর কি করে? ডাকুন 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 পরটা এক কাদা আপনি তো বলছেন 70টা 79টা মামলা করে দিয়েছেন হ্যাঁ কখন ডিকটেশন দেবো আর কখন এরা লিখবে ঠিক আছে
Lordship, page 8 is the written complaint.
from the house of the petitioner.
3 accused persons were arrested. I'm on statutory bail point, Lordship. 3 accused persons were arrested on 3/9/2024 and produced before the court on 4/9/2024. The 180 days was completed on 3/3/2025.
Where have you taken up the point? What is the ground on which it is rejected?
Lordship,
What is the ground on which it is rejected?
Lordship, the co-accused was granted bail
The bail
on page 19.
is accused. Granted bail by whom?
By High Court, page 19,
19.
page 19. Now, Lordship, what happened? I have annexed all the copies. Kindly see, Lordship.
When was he first produced in court?
Lordships, CD not received, my lord.
That, yeah,
They-
কত করে
18
মামলা হচ্ছে
to-
এখন বলছিস?
Lordship, I just check, sent by junior to check.
Not
Not-
today.
Lordship, the certificate copy I have.
But CD is also required, my lord.
সিটি কালকে নিয়ে আসো। Give the
Oh,
certificate.
certificate copy.
I sent my junior to check up whether this.
Lordship, I have annexed all the copies. Unrepresented Lordship, this petitioner. Then certificate copies are there, Lordship.
ওটা একটু ভালো করে দেখে দেবেন সার্টিফিকেট কোড।
Lordship, item number 18, Lanet DSJ appearing, Lordship, Lanet DSJ is suffering from.
Lordship, no. Lordship, in item number 18, I'm praying for 1 day's accommodation.
কে একদিন not today, কালকে।
Lordship, I'm great.
Next. Next. You are bearing Mr. Chakraborty, 19?
18.
19?
19, I think.
Well, I am preparing for the petition.
Who is for the state? Tomorrow. Next.
My lord,
20, yes.
20 of CD is not. CD
It's not there. What happened?
12 bottles of cough syrup.
Huh?
12 bottles of cough syrup.
Yes. আর তার সাথে একটা কি আছে?
In custody and charge sheet submitted, more than 6 months in custody.
Actually, brown sugarটা বলছি।
Brown sugar is the intermediate.
হ্যাঁ।
Intermediate quantity.
My lord, one day.
Tomorrow.
Grateful one.
Order passed. Extended extended the liberty of anticipatory bail. Petitioner as such may be also extended with the same benefit. Acha. I've considered the directions passed in CRMA 327 of 2025, where it has been categorically observed that the accused allegedly spoke to the applicant and promised him oppose a political party against payment of a sum. However, the said payment was not parted with, and there is only a case of attempt to cheat the present petitioner and another. Having considered the same and the statement of the witnesses, I am of the view that
Well, my objection may be recalled.
Oh.
I understand.
I am of the view that the same. I am of the view that the petitioner may be easily released on anticipatory bail. In spite of the objection raised on behalf of the state.
And let him meet the IO, investigation is going on.
Whatever the same conditions. Are low, okay? Anyway, the petitioner would cooperate with the investigating officer and make himself available as and called for. It is directed in the event of arrest, 7 number paragraph page 16 দিয়ে দেবো, black করে দিচ্ছি। mark করে দিচ্ছি, paragraph 7 টা দিয়ে দেবে, এই condition একই, দুজনে আলাদা condition করে দাও। Grateful man. কোথায় mark করে দিই?
Back on the report.
Just wait a minute, wait. Allow to dispose of the CRM allow for. Next.
There is a long-standing land dispute between the parties. Total 4 persons are FIR named. Out of 4, 3 are on bail by the anticipatory bail by the landed session judge. I have annexed the order, my lord.
So have you tried your luck before the session judge?
Yes, my lord. That was rejected.
Answer. The injury report দেখতে হবে তাহলে।
But charge sheet submitted, my lord, at any condition.
And
Charge
my
sheet
lord, 8
submitted,
and 9 is the 161 statement of the eyewitness.
নাকটাই ফাটিয়ে দিয়েছে।
charge sheet submitted, my lord, further,
নাকা দাঁত ভেঙে দিলে হয়।
my lord, further customer land.
It's a victim lady, my lord. And eyewitness is the page 8 and
Eyewitness statement of the victim.
statement on the victim, my lord, page 10.
My lord, charge sheet.
My lord, page 25 and 26.
Well, I go,
No, my lord, page 10, 16 and 17, maybe. My lord, I'll just.
নাম কি ভদ্রমহিলা?
my lord, Rafiqul Islam.
না,
petitioner is-
অপিরন বিবি।
Yes, my lord. 161 statement is 10, 16, 17 and 19.
সবাইকে মেরেছে।
Yes, my lord. There is a.
আমি সাবিদুলকেও মেরেছে, এক গাদা লোককে মেরেছে তো। তাহলে
My lord, as per the FIR, my lord, allegation against the all at same, my lord, as per the FIR.
Page 25 to 89 is the medical report and they are admitted in the hospital also, my lord.
রাফিকুল
Rafiqul is the principal accused, my lord.
But as per the FIR, আসামি নম্বর 2, 3 এবং 4 আসামিগণ তাহাকে লাঠি দিয়ে assaulted also, my lord. They are also assaulted. They are granted anticipatory.
আজিজ মিয়া, তাহলে মিয়া আজিজ, আমি মিলে আমাদের কেউ দূষণ হয়। গালিগালাজ কোথায় আসছে? না, go and surrender রে, মারধর করেছিলাম।
But charge sheet submitted,
না,
my lord,
গয়না
kindly
থাকবে না।
consider. Charge sheet submitted, my lord.
বুক না ফাটিয়ে দিলে হাইকোর্ট অ্যান্টিসিপেটরি বেল দিয়ে দিলে কি এফেক্ট হবে
মা-
সোসাইটিতে, কি বলবে?
My lord,
Yes,
charge sheet submitted. My further custodial interrogation is not
Grateful, my lord.
kindly.
Go surrender. Learned advocate appearing for the petitioner submits that similarly placed accused persons have been in granted anticipatory bail, charge sheet has already been submitted in connection with the instant case. As also the fact that other accused persons have been granted bail.
Anticipatory.
All anticipatory bail.
Yes, ma'am. Three.
তাহলে ওইটা দেওয়া দরকার নেই, last এটা দেওয়া দরকার নেই, তাই না? Anticipatory by the learned sessions judge. Huh? Petitioner accordingly submit is that further petitioner for the submit since the charge sheet has been submitted a detention of the petitioner in connection with the instant case is unwarranted. Full stop. Next, an advocate for the state produces the case diary as also the medical documents we each reflect the injury is sustained by all the accused persons, including one appear on BD. Having regard to the nature of injury so sustained by the injured victims and their statement, and on a consideration of their statement, I'm not inclined to really
Grateful.
the petitioner on anticipatory bail according to ECRMA 360 of 2025 is dismissed.
Grateful.
Lord, in 34, I am for the petition.
Yes.
My lord, at the outset, I must submit that essentially a civil dispute has been given a criminal color, my lord.
Probably to the
Now, my lord, this petitioner happens to be the owner of 43 decimals of land within a particular moja. Now, my lord, the complaint essentially states that in 2017, the petitioner sold 5 katas of land to the complainant. And my lord, thereafter, on the basis of the power of attorney executed by this petitioner in favor of one person, he sold off another 5 katas of land. Now
you sold to Shashi Bhujel as also Deepak Chetri.
No, my lord, Deepak Chetri is my registered power of attorney. He is my attorney holder. My lord, I'll just place on record 2 documents to show your lordship that there is no criminality in this.
Please show the document.
Yes, my lord.
Which document they can where is that?
My lord, I'll take your lordship to the schedule of the property at page 11. This is the schedule of the property
Yes.
which the complainant states to have purchased from this petitioner. My lord, we'll see the 3rd line onwards. Khotian number RS42 LR2615 appertaining to and forming part of plot numbers RS29 LR493 within Moja such and such. So, my lord, the plot here is LR493. Now, my lord, the subsequent deed, which was registered on the basis of a power of attorney.
That I will not see until and unless it is over here.
No, my lord, this is the document that they are relying upon. This is the document, my lord, takes up the complaint, my lord. It is referred to in the complaint.
On affirmation, without affirmation, I'm not.
Lord, then I'll file a supplementary affidavit.
File a supplement.
Yes.
Learned advocate for the petitioner intends to file supplementary affidavit incorporating the title deed of title deed. What
Yes, my lord, title deed.
title deed of property. A copy of the same be served upon the learned advocate appearing for the state as well as the opposite party number 2. De facto complaint. কবে করবো এটা?
My lord, day after, tomorrow I'll
Day after হলে হবে? Please,
my lord, tomorrow then later in the day, I'll
one day they will take to take instruction also.
yes.
Release the anticipatory bail application on 19th June 2025, even at the same edition. Next section.
But 35 I'm for the petitioner.
Yes, for the state.
The key delete.
Victim recovered or no?
Yes, my lord.
Victim
2
recovered?
days later.
Yes.
My lord, I'll
From-
place on record just one document. This is a,
Why do you give this type of document? I don't accept.
my lord.
Without
I'll-
affirmation, I'm not going to accept.
Yes.
it.
My lord, the victim was recovered 2 days after. As against this, my lord, Avinash Thapa and Amit Rai. These are, my lord, omnibus allegations. And my lord, the main accused, he has been granted bail. That is at page 11. Suraj Limbu has
Lordship,
been
so far my little understanding, this is not at all a case of anticipatory bail because Lordship, it was a there was a demand for a ransom of rupees 50 lakhs, and one Ekramul Hawk was abducted, and he was forced to pay 2.5 lakhs and 1.6 1 lakh 60,000. That is 4 lakh 10,000 was paid. After that, and even the when he was eloped, that CCTV footage was there in a Tata Sumo. Subsequently, in the hotel where he was taken, the hotel register is also yes.
Yes, my lord.
In 164, Amit Rai's name has been clearly stated. I marked with pencil. In the last pair, Amit Rai's name has, and this petitioner's name have been stated. And Avinash Thapa's name had been transferred from the statement of the co-accused. This is a case where in the FIR,
Three persons were firstly arrested. If I may place my case for 2 minutes. প্রথমে তিন। কিছুই তো দিস না।
and the investigation is still on.
কোথায় ফরওয়ার্ডিং কি করে দেব?
Amit Rai. Second petitioner is the Amit Rai.
Amit Rai is the person, my lord, who handed over the victim at the police station.
Where is the complicity of this person?
Lordship, the 161 of the victim, 161 statement of the victim, that has also been recorded. The pagination is not correct. Let me, Lordship, if you kindly provide me the case diary.
154 has been recorded, sir. After that, 161.
What?
I don't understand one thing. This person went to the police station
Yes.
with the victim.
Yes.
Yes. After when the entire there was a hue alarm was raised, there was a hue and cry at that time to save his skin.
So
And the investigation is still on, Lordship.
there was a business rivalry that.
Yes, my lord. I was
But he was abducted. He was abducted through a video call.
At
through a
best, there is a case of abduction. It is a bailable offense. There is no ransom recovered, my lord.
So
No.
this was,
Abduction, my lord, is a
Avinash
bailable
Thapa, what
offense.
do you have against?
Avinash Thapa's name had been transferred from the statement of the co-accused who was arrested in Suraj Lumbu, and also the de facto complaint statement, de facto or victim statement. In the victim, Lordship, the pagination is not correct. Please kindly allow me to show the page.
So I ordered the case too.
Huh?
If the pagination is not done, that means IO is playing with the accused persons. Yeah, case কোন থানা? কমিশনারের এই অবস্থায়।
The statement of the victim is also there, Lordship.
The 164 is statement of whom?
Victim.
The
The CCTV footage of the hotel, the CCTV footage of the Tata Sumo when he was abducted by a Tata Sumo vehicle, 4 persons came down, said we have a
Sir,
complaint.
tell me one thing, whether the accused knew the de facto complaint earlier or not.
No, not at all.
তাহলে বিশেষ তাহলে কিসের টাকা চাইতে গেছিল? 2.5
No, abducted for ransom.
for ransom or for business rivalry? That is what I'm asking you.
Huh? Someone engaged them. Someone
Who
engaged
is the
them.
someone? Now the investigation.
Investigation is still on. And
So someone means somebody, some person must be there who engaged him by this time.
for that reason, custodial interrogation of Amit Rai is
See the
required.
order granting bail.
Amit Rai is
Other
required.
persons were arrested. Where is the statement of the other accused persons?
Lordship-
Who engaged them?
Their statements is also there, but the pagination is not correct at all, Lordship. And the charge sheet is still pending, Lordship.
Lord, if I may clear the fog, my lord, there is nothing in this case. Admittedly, there was a business rivalry. At best, there is a case of abduction. For 2 days, my lord, after that, he was
Who are
handed
these
over to the
persons?
police.
Recovery agents.
No,
Who are these persons?
They're abductors.
That means they are recovery agents. What are the, who are they? Tell me. Abducting.
They're actually they are engaged in all type of antisocial activities, and they are also engaged for different type of criminal activities. These persons. Actually, who is the kingpin has to be determined. হলো না কেন? 12 দিনের কেস কি আইপ্যাড হলো না, এখন কেন হলো? Lordship, may I be permitted to read one portion of the memo of evidence?
What is your case?
Now, my lord, admittedly, there was a business rivalry between these persons. I'll take your lordship to the written complaint. At page 10, it talks about a bank transaction of rupees 1,50,000. That is, my lord, a very easy evidence for the prosecution to, my lord, gather. My lord will see from the case diary whether there any bank statement has been, my lord, recovered. These are all, my lord, stories conjured up in the thin air. He was abducted for 2 days. He was kept in my custody. After that, I handed over. I'm not admitting to any guilt. my
And
lord.
is that
At best, my lord, there is a case of abduction. No, my lord, demand for ransom. The ransom money has not been recovered, and it talks about a, my lord, bank transaction. That is a very easy evidence for the prosecution to gather.
But two is the main person basically.
My lord,
He is the person who engaged the other person.
my lord, even his involvement has come up from the confessional statements of the co-accused. My lord, no value in the eye of law.
at this stage, the
No,
charge sheet is pending.
The 160 was statement, no value.
my lord, he has handed over the victim. The petitioner number 1 has no complicity.
He is the person who has engaged all these persons.
No, my lord,
Yes,
certainly not.
yes, Lordship. This is the case. This is the
Lord,
case.
if
This
I-
is the case. Lordship has actually
Lord,
rightly pointed
There's no
out.
case for custodial interrogation, my lord. I am on that.
The contact.
My lord, the victim has been recovered 2 days later on.
My
2 days later.
learned friend has a soothing argument.
2 days later, my lord, the victim was recovered. He was handed over by Amit Rai.
This is a fit
before
case
the
for
police
custodial
station.
interrogation,
The
Lordship.
police did not think it fit to arrest him at that point in time. At that point in time.
No, because he was not out there initially. Avinash was there at the hotel itself,
Yes.
along with the others who were arrested.
No, my lord. When
From the
Amit Rai
CCTV
handed
footage.
over the victim at the police station, that is the victim's statement. At that point in time, the police did not think it fit to arrest him.
Because you gave a different story.
No, my lord. No, my lord. The victim was handed over. The victim could have given any kind of a story that he wanted against me or my lord, for me. Ultimately, his 164 statement was recorded. On the basis of that, and on the basis that no ransom was recovered, there is no money trail, no bank statement, nothing. The additional sessions judge was pleased to grant bail to the main accused, Suraj Limbu, who was firstly arrested.
That's a bail.
Yes, my
That's a
lord.
bail, not
That's a bail, not an
Now, my lord,
anticipated
I'm on
bail.
the same footing, my lord. The allegations are omnibus against everyone. My lord, the allegations are omnibus, my lord. My lord, kindly considers against the petitioner number 1, there is no complicity. Against the petitioner number 2, there is a bona fide. He handed over the victim to the police station.
No,
Why is the case for custodial interrogation, my lord? Kindly considers that.
I should draft the grounds of arrest for you.
My lord,
You want that?
that is another ground, my lord.
I'm giving that, sir.
My lord, no, my lord. My lord, certainly. Milord grants me a limited anticipatory bail, I'll surrender, Milord.
Lordship,
Or
this is
Milord,
not at all a case of
I will be present before the,
Maybe a good case for bail, sir, I don't know, but not.
Milord, before the police station, I'll be present every week, Milord. I'll be present every week, Milord. Milord, Milord kindly considers my prayer for petitioner number 1 at least.
Petitioner number 1 was present.
Was present on the spot.
You engage hoodlums. Amit Rai engaged the hoodlums.
Milord, at best there is a case of abduction, Milord. That is a bailable offense. Kindly considers that too, Milord. There is no ransom recovered. There is a clear finding in the order of the Honorable Sessions Judge.
No, I don't go by the order of the section.
Session
There is
judge,
a clear
session judge order
finding.
is not binding upon,
The
not
Sessions
binding
Judge,
upon.
Milord, has considered the case diary, and Milord, as a matter of fact, there was no ransom.
Lordship has also.
There was no ransom demand, Milord.
I'm concerned.
There was no ransom demand, Milord.
There was a
Milord.
demand. There was a
No,
demand. There was a demand.
Milord, 2 days later, the victim was handed over. Kindly, if
pressure, sir.
if there,
On
if
pressure.
there, no, Milord, no pressure. The Milord, on the second day, the FIR came to be registered. On the day thereafter, he was handed over. Milord, had there been any demand for ransom, he would have been kept in their custody for a considerably long period of time.
Not a case for anticipatory.
After that, he would have been handed over, Milord.
Petitioner.
Milord, kindly considers, Milord, a limited anticipatory.
No, petitioner as
Milord, on any condition, Milord. Milord, if that is the case, Milord, I'll go beyond the jurisdiction of the police station or the district, Milord. I'll reside beyond that.
This type of
Milord,
person
no
can
case for
operate even staying outside the jurisdiction.
Petitioner as learned advocate appearing for the petitioner aims at there has been a business rivalry pursuant to which the petitioners have been falsely implicated in connection with the case, and the evidence and the materials so collected by the investigating agency would go to show that it was a petitioner number 2 who had handed over the victim at the police station. Full stop. Learned advocate emphasized that other accused persons who were arrested have been released on bail, and there are specific observations of the sessions for which granting in respect of the materials appearing in the case diary. Full stop. The present is a learned advocate for the state. It opposes the prayer for bail and has handed over the case diary. Full stop. It reflects that the petitioner number 2 engaged the other persons for the alleged offense is committed. And in the CCTV camera, it has been seen that the petitioner number 1 was present at the hotel when the victim was confined. Full stop. Records further reflect that for 48 hours the victim was confined. Having regard to the gravity of the offense, I am not inclined to grant the petitioner the both the petitioners the benefit with accordingly CRM number 373 of 2025 is dismissed.
Much obliged.
Deep pleasure.
Yes. Yes, sir. Married or what? Who is there? You.
Lord, item number 36, Mr. Shuang Ghosh is there, my lord. He is not well as. That's why he did not come to the court today, my lord. Kindly this could be taken up tomorrow.
Do you have any, this 164 is there? This,
My lord.
both of them are married?
No, my lord. I do not have any instructions.
So we can easily.
In this case, the lordship has said de facto was there. I think they want to marry. So that is why de facto was there.
Let them come tomorrow, maybe. Let it be not the same. Chilo to something.
Next circuit time. None appears for the petitioner. Learned advocate 8 for the city is present. List the present application for anticipatory bail before the next available circuit bench. Arish of Derek and Lavin. Those to 37.
In item number 37, I beg to appear on behalf of the petitioner.
Yes, Your Lordship.
This is a case under section 137(2) and 143 of the BNS, added section 4. Here the accused person is also a minor. I have annexed the birth certificate of him.
So
at
minors,
page number 7.
minors anticipatory bail is pending before the special bench.
Lordship, yes, Lordship, but there are three judgments of our High Court. Two says yes, maintainable, and one says no, it is not maintainable. The last judgment where I appeared before my lord, before a division bench, that bench has considered the two judgments and thereafter said that yes, it is maintainable.
Lordship, I am relying on this judgment of the Sahana Khatun. Sahana Khatun and others of the state of West Bengal, the division bench of Justice Banerjee and Patnaik, where it has been stated that not maintainable.
Other judgments also there.
Other judgments, contradictory judgments are also there. Contradictory judgments are also there.
But consider the last judgment
Yes.
passed by my
Matter is for 3 judges bench.
What is there in the 164 and medical leave? चारे मामला तो नहीं.
yes, Lordship, section 4.
Section 4. Clearly stated that rape was done. Rape was committed. Page 50.
Age of the victim.
Age of the victim 14 years.
Age of the tomorrow.
Yes, sir.
Just see whether statement of the accused or
Yes, sir.
next.
39, my lord, I am for the petition. My lord, the allegation is
Who is
under,
there? State you were there.
my lord, the allegation is under section 80 and 85 of the BNS corresponding to 304B and 498 IPC. I am for the father-in-law, 68 years old, and the brother-in-law, my lord. The principal accused husband is in custody, my lord, and kindly, my lord, come to the FIR written complaint, page 9.
Anything against the parent, this father-in-law, brother-in-law?
161 statements are there.
Other drug addict husband.
Yeah, drug addict. So, my lord.
ওখান থেকেই ঝামেলা হলো।
Yes. Ganja addict.
Learned advocate appearing for the petitioner. Petitioners submits that the petitioner number 1 is the father-in-law and the petitioner number 2 is the brother-in-law. And they have been implicated in connection with the case as the daughter, as the wife of the other son has committed suicide. Full stop. The petitioners claim they are innocent of the charges, and they have been made accused because of the untimely death of the victim. And however, the main allegations, according to the petitioners, are against the husband end of the deceased. Stop. Learned advocate for the state producer is the case judge have considered the materials and also the fact that the husband, namely
Sujit Sarkar.
Sujit Sarkar, has been taken into custody. Having considered the same, I am of the view that the custodial interrogation of the petitioners may not be warranted in the fact of the circumstances of the case. According to CRMA 83 of 2025 is allowed. The petitioner would furnish bond of 20,000 to surety like amount to one of daily local arresting officer দিয়ে আর 432 আর 482 দিয়ে দেবেন আর ওখানটা দিয়ে দেবে the petitioner shall make themselves available to the investigating officer as and when they are called till the as and when they are called. Full stop. Accordingly, here we have to allow. Yes.
Correct, Lord. I'm appealing for the petitioner lordship. Allegation is under section 69, 88, 115 subsection 2 of the Bharatiya Nyaya Samhita.
What is the age of the lady?
21 years. Both are 21 years.
Both are 21. What did you promise?
So love affairs were there.
Marry,
Huh?
promise to marry,
But
but
it is there. Promise apart from that.
yes, my lord, 164 statement is there, my lord.
How many years of relationship?
2023 since.
What's your relationship? What do you do?
The student lordship, 21
January
years.
2023.
কি করে বিয়ে করবে স্টুডেন্ট? খেতে পড়তে দিতে পারে না কি? Age?
Page, my lord, 51 to 53. Not only one time, several times.
Seven times.
Consent from.
And when she proposed to marry, then he was refused. She was refused. Your charge sheet is pending, my lord. There is a
I
case
will
of,
cooperate with them.
there is a case of just April 2025.
That is different. Charge sheet pending মানে হচ্ছে কবে কাজ কেস? এপ্রিলে
April 2025, it was 14th April.
পুলিশ ছেড়ে গিয়েছিল তো হাইকোর্ট এন্ড police was not disturbing you. Now they have started disturbing you. After 2 months, they have started disturbing you.
The victim was first of, in the first incident, she was got pregnancy and that was aborted by
That is the
putting
allegation.
tablets. my
No,
lord.
no corroborative evidence is there.
Are you the one?
As per voter ID, she was only 20 years at the time of incident.
So consensual relationship. Kindly consent.
Promised to marry her, then refused. Well, kindly consider the medical legal examination report.
What purpose is consensual? প্রথমে পরিচয় হয় তারপরে প্রলোভন।
I mean, promise to marry and then refuse.
Promise to marry, both are
Don't
of
they
the
believe?
but then this is not a age difference case. Both are of same age. সেটাই করতে হবে।
People also kindly consider 13, page 13 and 14, medical legal.
Medical is there because she admits. কাস্টডি নিয়ে কি করবে আমি যেটাই ভাবি। আর তো ইমপ্রুভ করার কিছু নেই। 160 were collected, medical collected. আর তো কিছু নেই। Learning advocate appearing for the petitioner submits that the petitioner was in a relationship with the de facto complainant and and even if the allegations in the FIR are accepted, be correct, there was a consensual relationship between the petitioner and the and the de facto complainant. Full stop. Learned advocate aid for the state draws the attention of the court to the medical legal examination report, as well as the state. The 164 is there, no? 164 is there.
Yes.
As well as a statement end of the de facto complainant under section 164 of the CRPC. Where is the 164?
My lord, at page 51, my lord.
Against a polling as well as a statement under section 164 of the CRPC. Having considered that there was a steady relationship existing and subsequently the petitioner did not to marry, we the de facto complaint we each led to the registration of the present case. I am of the view that custodial detention of the petitioner may not be warranted in the facts and circumstances of the case. Accordingly, the prayer for anticipatory is allowed. We are Bishop we are arresting officer arresting officer. The petitioner shall meet with the investigating officer of the case once in a week till the submission of the charge sheet.
I'm grateful.
41, my lord, I am for the petitioner, my lord.
Yes.
Lordship,
My
I'm
lord.
praying for the Union of India. Lordship,
My lord.
learned DSGI is suffering from illness, Lordship.
Huh?
Suffering from illness, Lordship. The DSGI.
My lord.
Lordship.
DSGI is not appearing.
My lord, may I tell your lordship, I know, my lord, Mr. DSG is not appearing, my lord. Difficulty is that, my lord. Just give me 2 minutes, my lord. My lord, kindly see the affidavit of service. The EO has refused service. Now, my lord, DSG is ill, my lord. What they have done, my lord, since filing of this anticipatory bail, the EO has become active and they are trying to raid my godown, though my godown name is nowhere. My lord, kindly see once, page 39, once, my lord, my satisfaction, then, my lord, grant time to them, page 39. My complicity comes, my lord, in page 39. Innocent person has been tagged on the basis of statement of arrested some persons. I don't know them at all. They said, I am the owner of a godown called Bhagat Enterprise. I don't know Bhagat
It is also
Enterprise.
required, Lordship.
Go slow, sir. I'm putting it in the next circuit.
Lordship.
Ask your inquiry officer to go slow, sir. Since you
Yes,
are praying for time,
Lordship.
Ah.
Paper and CD also required, Lordship.
no, whatever is required that you will produce, I have got no business.
My lord,
But,
kindly
since-
protect me for a limited period. I will cooperate with the investigation.
Since you are unable to do the case, please ask
Okay.
the officer to go slow. Huh?
Lordship.
Mr. De Learned Advocate appearing for the petitioner submits that although accommodation is sought for on behalf of the Union of India on personal grounds of the learned Deputy Solicitor General, yet the investigating officer has weighed all his initiatives started to harass the present and petitioners who were not named in the initial complaint. Be that as an accommodation has been paid for on behalf of the learning DSG. Since an accommodation has been sought for on behalf of the Union of India, I am of the I direct that the inquiry officer of the case who would go slow till the next available circuit. You just go slow, sir. I have
Lordship, one in this and CD is required can.
CD is there in RPUP.
Lordship.
My lord, everything certificate copy is annexed, my lord.
Case records are there, sir. CD is not because the complaint is filed. There is no case diary.
My lord, my lord, since my lord, kindly protect me for some weeks, my lord. I will cooperate with the investigation because
I'm
there is a
asking-
provision, section 9, my lord, for
I am
summoning, my
asking
lord.
them to go slow, sir. কি বললাম?
My lord, they will interpret the slow, my lord, in
Go slow. TAAL, the application for anticipatory bail is taken up in the next available circuit bench.
Grateful lordship. EO's report lordship required.
Huh?
EO's report. EO.
IO's report is
Hmm.
there that you have got to bring, sir, that I cannot direct because there is no case diary in our PUP cases. Sure. Oh, service, oh, yeah. Effective aid by either petitioner as well as the affidavit of service be kept with the record, sir.
Grateful lordship.
deeply obliged.
Staying for 1 day accommodation.
Not,
City is not there.
not today.
Grateful.
Next.
43.
Yes, sir. Yes, sir.
Lordship, yesterday, that
Yes, sir.
the statement recorded or not.
My lord, as per the customs, they have stated that two vehicles, they have given the number. They have entered into Bangladesh through the border. That is the report of the customs. I have folded it.
And that particular
Another-
document which has changed the slot.
My lord, those we have given the photocopies that has been certified by the in charge land customs.
Land, that is a, how are you saying this is a forged document?
They have stated.
On the basis of what? You have got to
Lordship,
explain
those
that.
documents we
Those are-
annexed, Lordship.
No, I understand that they have.
No, those explanations are some. Only the name, the slot name is different and the vehicle which is given, that is different.
So what is the statement of the customs officer?
Customs statement. No statement is there. I've gone to the interview.
এত মোটা কেস জারি নিয়ে কি হবে?
শুধু গাড়ি, all the vehicles papers, they are worried about the vehicles and release of the.
Lordship, we also annex all those.
All vehicles are given in
This is all the
Jimbanama,
vehicles.
those are there, full vehicles document.
কাজের কাজটা কোনো 3 পাতা সেদি হলে কাজ হয়ে যায়। Whether the offense is made or not is to be voluminous case diary is what will happen, sir.
Yesterday I've gone through the entire case diary after my lot of stated.
Lordship, cooperate with the investigation, Lordship. Magistrate travel case, Lordship.
হ্যাঁ,
41
তো prima
notices not
facie,
served.
till date কবেকার ইনভেস্টিগেশন?
The case
কবে
of
হয়েছে?
8th of April.
এ তো বিজনেস ড্রাইভার লেগেছে, বেসিক্যালি খবরটা দিয়ে দিয়েছে। পেছন থেকে গাড়িটা তুলে নিয়ে বেরিয়ে গেছে, রেগুলার জিনিস। What was there in your vehicle?
Boulder, Lordship.
Boulder?
Yes, Lordship.
Boulder তো বেশি টাকা দাঁড়িয়ে থাকতে লাগে। চলে আসো।
বাংলাদেশে boulder পাওয়া যায় না।
Any condition, Lordship, cooperate with the investigation. Lordship.
And the advocate appearing for the petitioner submit that he is innocent of the charges and has been falsely implicated in connection with the case. And there has been no occasion to prepare or manufacture any document or a regular carrier who is licensed and who had been carrying on business for a considerable period of time. Full-stop learned advocate aid for the state submit is that there are 2 documents which have been collected by the investigating agency from the Land Customs Department,
My lord.
Land Customs Office, which reflects the slot which has been referred to. However, the said document, which is the foundation of the alleged forgery being committed, has neither been placed before the appropriate authority in order to ascertain regarding the genuinity of the same, as has been submitted by Mr. Chakraborty, an additional public prosecutor appearing on behalf of the state. having considered the fact that the case is exclusively based on documents, I am of the opinion that prima facie custodial interrogation of the petitioner may not be warranted in connection with the instant case. Accordingly, the prayer for anticipatory bail is allowed. ওই একই এরিয়া দেবেন ওই সব 10,000 to surety is one of whom must be local to the satisfaction of the arresting officer. গেল ওই তারপরেরটা হচ্ছে 432, 482, তারপরেরটা হচ্ছে এটা দেবেন the petitioner shall meet with the investigating officer. Petitioners shall meet with the investigating officer of the case once in a week. They will further order us till submission of the charge sheet. And this order of anticipatory bail will remain in force for a period of 6 weeks. Are we accordingly CRMA 387 of 2025 is disposed of. Allowed but disposal of যেটা ইচ্ছে। 44 who's there? Next circuit, next circuit.
Maybe it's not audible. Can we fix it on Thursday? It's not audible. The advocate is.
It is not there.
Next available circuit bench করে দিচ্ছি আর নয় হয়ে গেছে অনেক সার্কিটে কাজ এটা রেডি হতে পারবে না আচ্ছা learned advocate for the petitioner pays for an accommodation. State also pays for an accommodation. Accordingly, he lists the application for anticipatory bail before the next available circuit bench. Next.
I'm for the petition, my lord.
There you go. Who is for the state?
45, Lordship, I'm praying for not today.
Not today. Next.
46.
Lordship praying for 1 day accommodation.
CD is there.
No.
হ্যাঁ তাতেই তো শেষ করে যাচ্ছে।
47 Lordship, I am for the petitioner. Mr. Lordship, paying for
1 day Lordship.
Not today, চলো।
48, I'm for the state.
I'm for the petition, your lordship.
Is child recovered, daughter recovered?
Recovered. And her judicial statement also been recorded.
My lord, in this case, I will invite your lordships kindly consider the medical report. And from the medical report, it is clear that the 15 years minor girl.
Ask you, I have to be present tomorrow.
Birth certificate.
Which police station? Which police station? কোতোয়ালি তো এখান থেকে হেঁটে চলে আসবে কালকেই থাক কাম টুমরো স্যার নট টুডে কি আরম্ভ করেছে কি পুলিশ
15 years girl.
আরে তাই যদি হয় তাহলে তো বক্স অ্যাড করতে হবে তো স্পেশাল কোর্টে মামলা অটোমেটিক্যালি চলে যাবে
Obvious. 164, nothing has been stated, but the medical is corroborated.
that the IO will say whether he intends otherwise anticipatory দিয়ে দেবো বেতন এই
49, I am appealing for the state.
And for that.
49 yes
Lordship.
what is your
Charges has been framed under section 325. 3 years has been convicted.
what is his grant for bail
Confirmation of the
Yes,
bail.
yes.
bill তো পরের দিন হবে আগে অ্যাডমিশন হোক তারপরে
Admission has been done.
admission done
Yes, your lordship.
you have been granted bail
Yes, your lordship.
interim bail by the trial court
Yes, your lordship.
learned advocate appearing for the petitioner submits that petitioner oblique appellants how many 2 appellants 1 appellant submits that after a conviction the learned trial court on an application possibly is to release the petitioner on entry in bail for a limited period of time having considered that the petitioner was throughout on bail during the trial
Yes, your lordship.
throughout on bail
Yes, yes.
was throughout on bail during the trial. I am of the view that during the pendency of the appeal, the petitioner may be allowed to continue on the same bail and bond, but on condition that on each and every month. The petitioner shall attend the trial court and obtain an acknowledgement from the office of the trial court. Full stop. If there is any change of address, the same may be furnished by the appellant, public petitioner to the learned trial court. And the learned trial court would in every 6 months submit a report in respect of the compliance made by the appellant. In case of any violation of the aforesaid conditions, the BAL order would automatically stand cancelled. Full stop. Accordingly, CRAN 1 of 2025 is allowed. Good. Actually, a character আছে না? এটা কি আসবে? Yes, what is it?
My lord, 4 years punishment for section 8 POXO and 3 years for section 12, my lord.
You were on bail through
I am for the statement. This is a criminal revision, my lord, against an order of judicial magistrate, third court, which Bihar, my lord.
Yes.
Last page is the order, my lord.
Yes.
Microphone.
An FIR has been registered against me. Subsequently, a charge sheet has also been filed. And when I appeared in the court, the honorable and for defense, the honorable court has supplied me that copy. And while receiving the copy, I found that a significant document which has been filed with the charge sheet.
Where is the charge sheet?
The charge sheet is at page 14. Kindly
Which
see the
document? Document?
last page of the charge sheet, my lord.
Yes.
During the investigation,
Separate 107 case. This is not a part of this, this document is not part of this investigation.
Page 15, page 16.
16, my lord.
14,
Uh,
16.
During investigation,
During investigation, I also received a Mars petition, something else, from the villagers that the accused has threatened the villager with dire consequences. So this is relevant. This is in connection with the present case. The allegation is relating to the present case. And the allegation is of criminal intimidation. However, the charges has been given for breach of peace, something like.
A separate
Yes.
proceeding was drawn up.
so why have you written that over here?
Who has written it? But this document is not with the city, but I have received the
So
instruction.
why did the investigating officer write this over here?
There's,
Try to appreciate once.
Unnecessarily.
Unnecessary. You, in the list of documents, you have said nil.
Yes, ma'am.
Now this is a aspersion over here upon the accused. Rightly, wrongly, this is a character aspersion against the accused. Now you have written the case number, everything. And you see, I also collected the injury report of Radharani Karji. Why have you given this as nil? You see serial number 10 of the charge sheet. You have got the case diary.
No, my lord, I thought whether will not be.
I also thought that thinking is not always perfect. That he has got substance in his application. Had you been silent on these issues, he would not have
Would not
wanted
have
that.
come up with this.
Now you have written this.
My lord,
On a-
107 proceeding, that copy can be obtained from the executive magistrate.
But that is not his duty. You are
Yes,
relying
it's
upon
not
that.
registered. No case number, my lord. Only non-FIR. What is the case number? NGL,
No,
no
another
NGL case
injury
number.
report is also there.
You see, my lord, no.
Have you supplied
NGL
that?
number.
Yes, yes.
You don't
Injury
talk
report
when
is
I'm
enough.
speaking. You are appearing in person doesn't mean that you will get a separate leverage.
No, I'm not.
Behave yourself.
Not saying.
The observations of the learned trial court is not very acceptable to this court also.
Yes.
You tell me, Mr. Biswas, you have collected the injury report. You have said that, sir.
Yes, my lord. But the order sheet reflects that all copies were given to him.
So what are the copies you have given to him?
He has given a note of satisfaction there also. Well, that is in the order sheet also. His endorsement is there.
No, that is all right. But then he has wanted a document which you have said. The investigating officer has got to give a clarification to that effect. Why did he write this in the 173?
Yes, my lord. He has created the trouble actually.
When did you were served earlier? No, now.
No, earlier I received. I thought the case diary wouldn't be required.
I also thought that, but that doesn't mean that, he has got a substance in his application. Next circuit, I'm giving it, sir.
Thanks.
Petitioner
My lord,
has prayed for, you prayed for documents that they will supply, sir. If they have, otherwise this would be expunged from
my
the.
lord, kindly consider the learned court hasn't referred to case diary in the order, impute order, but he has, the court never ordered for the diary in the during
The order
hearings.
is
Yeah,
there.
this is very serious illegal.
What is serious? You have got to wait for the case diary to come.
No, there are several proceedings, my lord. That is why I have said abuse of the process. Several proceedings have been conducted, my lord. I have appeared sincerely on all the proceedings.
No,
but-
that you have appeared, but the thing is that you have come against an order where you wanted a mass petition. This is your application. Page 18.
Yes, my lord. The
Page
learned,
18 is your application before the court.
yes, ma'am.
The response is in the order. So I'm directing him to, if they let the case diary be produced, otherwise the state will, this part of the report would be expunged.
The order sheet represents it is not relying upon that mass petition.
No,
Yes.
your reliance is
Lordship,
something different.
kindly
Now the
consider-
reliance is not required.
Lordship, kindly consider draft rules on criminal practice, which clearly says all the documents relied upon or not relied upon need to be given to the accused.
That
That
has
would
been
help
settled
the
by the
accused.
Supreme Court. As a petitioner had the petitioner filed an application before the learned trial court for supply of the documents, particularly a mass petition which has its reference in the report under section 173 report, CRPC 173 CRPC report in reference to
Yes, case number to one photo. Yes, case number. Another case number. Full having photo here.
NDPS.
in reference to Pundibari PS case number 168 of 2020 dated 8/19/4/2020. Mr. Viswas, you come to page 15 of the brief. You see at the bottom over here, this is a signature of the investigating officer on 30th April 2020. The next page, page 16. This is again dated 31st of May 2019. And there is no serial number of this. During investigation, the paragraph starts. Huh? You were signing this document, I don't know. 30th April 2020. Again, you are at the top of this page 14, you see, you are submitting a charge sheet of 19th April in a case registered on 19th April 2020 on 31st of May 2019. Charge sheet of 2019. And how come within 11 days you have submitted the charge sheet? এই মামলাগুলো দিচ্ছে এখন পিপি অফিস থেকে হ্যাঁ even if it is 34/2020 within 10 days you have submitted the charge sheet. জানি না কি কাগজ কি তাহলে মামলা দেওয়া ইচ্ছাই নেই কারণ মামলা করা আর কি বললাম full stop. The charge, Mr. Biswas enters appearance on behalf of the state as a copy was already served on the office of the additional public prosecutor, High Court at Calcutta Circuit Bench, Jalpaiguri. The advocate for the state is directed to produce a case diary and seek for an explanation in respect of the charge sheet, which has been submitted before the trial court, and the irregularities which have been pointed out. Full stop. এটা কাজ জেরক্স কি করে এর সাথে দিয়ে দিয়েছে মামলাটা শুধু শুধু দেরি হচ্ছে আচ্ছা the investigating officer will also clarify in respect of the documents which have been served upon the petitioner, as also the a list of the unreliable documents which the prosecution do not propose to rely. Full stop. Let the revisional application be listed before the next available circuit bench.
This is not completely.
Yes, revision motion.
Yes.
Direction was there.
No,
And how will service be completed?
first time appearing. The petitioner being the complainant of an act.
In appeal, sir, why are you special leave to appeal? You should file.
Dismiss for default.
Other dismissal for default under which section of CRPC? 256.
Yes.
That is acquittal. So you have got to file a
I'm the
special.
complainant, Lordship.
Huh?
I'm the complainant.
That is why non-appearance of the complainant.
Lordship.
So that's you have got to file a special leave to appeal.
Lordship, then kindly grant me liberty.
Since the order was passed under section 256 CRPC, bracket A, section 279 of the BNSS, petitioner would prefer an application. Petitioner should prefer an application under section 378(4) of the CRPC. Bracket A, section 419(4) of the BNSS. The present revisional application is misconceived. As such, the same is dismissed. Petitioner is granted liberty to take out an appropriate application. Certified copy department is directed to return the certified copy after the same is replaced by a photostat copy. Yes, sure.
Lordship, myself, party and person, I apply a petition under section 340 CRPC against a application filed opposite party number 2 Y.
So there is an appeal, revision will not lie, appeal will lie 341. This is order of which court? The civil courটের order এখানে কি করে হবে? Sir, this is a civil court, mat suit which was pending.
Not met should 24 section Hindu Marriage Act.
So that's a civil case.
Civil case.
Where you have filed an application under section 340.
340.
So first of all, if you are not satisfied with the order, you have got to file an appeal under section 341. Second, such 341 application is to be filed before the higher court of that civil court,
Lordship,
not before the criminal court.
Lordship, I submit a application.
That's on merit.
Another application, and learned additional district judge stay the order, stay 340 petition, still disposal of mat shoot and section 2.
Why have you come? Let me say, this is a problem with in-persons. Neither they understand the law nor they will be. Sir, you have come against which order? 13/3/2025 order. The 13/3/2025 order has been passed by the additional district judge in miss case number 3 of 2025 arising out of mat suit number 336 of 2023. Now that is a 340 proceedings. 340 proceedings. If you are aggrieved by any order, you have got to prefer an appeal, no revision lies. And then you file the appeal, then the appeal will go to the appropriate forum, the higher court of this civil court, not before this court. After the criminal case is registered, then only the criminal court comes. Here the application can be pondered upon only after consideration suit. Under 340, have you moved any application?
Sorry.
You have moved an application under 340 CRPC.
340, yes.
So that has been kept in abeyance. Stayed. So you are aggrieved by that order.
Lots. Change.
So appeal will lie, revision will not lie.
Okay.
You go with the next available. The petitioner appears in person and is unable to interact on issues relating to law. Let the revisional application be listed before the next available circuit. Has been ordered.
My lord, this relates to a criminal case under section.
Sir, against order of discharge.
Yes, discharge.
Rejected.
Yes.
The standard format. So look, petitioner is rejected. Who state? PS case.
State.
Petitioner is directed. Petitioners are directed to serve copy of the revisional application on the opposite party number 1 through the office of the additional public prosecutor, High Court at Calcutta, Second Bench Jalpaiguri, and also upon the opposite party number 2 by speed post with AD and while evidence of service is on the next day 8 fixed hearing. list the revisional application in the next available circuit bench. Petitioner prayer for entry order would be considered heard after appearance of the opposite party number two.
Stay of the order.
After opposite number two appears. Next.
Obliged, Lordship.
Actually, this is a transfer petition.
Serve. Petitioner is directed A to serve a copy of the revisional application upon the private opposite eight parties by speed post with AD and file affidavit of service on the next day 8 weeks hearing. List the revisional application in the next available circuit bench under the heading contested application. Well, next.
For the petitioner, my lord. This is an application for quashing of the proceeding. Actually, the case was initiated under section 406, 419, 420, 380 of Indian Penal Code. Subsequently, I was in.
Serve.
My lord.
Petitioner is directed A to serve copy of the revisional application on the opposite party number one through the office of the additional public prosecutor High Court at Calcutta Circuit Bench Jalpaiguri, and upon the opposite party number two by speed post with AD and file affidavit of service on the next day 8 weeks hearing. List the revisional application and the contested application in the next available circuit bench. The prayer for entry order would be considered after appearance of the opposite parties. Sure.
57 praying for not today. This
Why
matter,
are you saying not today?
this matter is led by Lordship, Learned Senior Advocate Sudipto Mujumdar. Due to his unwell, Lordship, I was been instructed.
Then why are you paying not today? Pay for next circuit.
Lordship, tomorrow, Lordship.
No. Tomorrow he is taking for Union of India. He is taking for long time, and for private bridge, one day it can't be. An accommodation has been paid for on behalf of the learned advocate aid appearing for the petitioner on his personal grounds. In view of the accommodation sought for, list the revisional application before the next available circuit bench. Next.
Lordship, I am applying for the petitioner. Lordship, I apologize on the last occasion I could not appear, Lordship. By an order dated 11/6, 11th June, your Lordship directed the state to file a report, Lordship.
My lord, in this case, the status report was called for, my lord.
Yes.
What happened, my lord? We have instructed the IO. He has served copy upon the complainant.
Argument completed over there.
In the month of April.
So what is left now?
Now, Lordship, my case was that, Lordship.
Arguments have been completed. Structure change হয়ে গেছে কেসের তো।
Argument completed 25th April. Now
the difficulty.
It's not in your favor. That's why you want to.
What are you wanting? Tell me.
No, Lordship,
আমি
in the
কিছু করতে পারবো না।
the 4 doctors were named, and the sections have been given under section 325.
To
Doctors,
file 311 over there, sir, I can't do anything.
Lordship.
আমার তো আর কিছু করার নেই। When you came to the High Court, it was at a difference.
Yes, it was.
Today, it's at a completely different.
311 at this stage, my lord, after
He
argument.
is a de facto complainant. He
Yes.
is a de facto
I'm not
complainant.
de
We have
facto
not examined the medical witnesses.
My lord,
Not even the
You
IO also.
understand? Huh.
for de facto complaint. It should be given at last.
তাই তো, you're the de facto complainant.
Yes. My mother was the.
Right.
I was the victim, Lordship.
Dr. Sujoy Go, medical officer of Tufanganj SD Hospital.
Only there are 3 other doctors' names.
CSW 10 and 12 and the IO. They were not examined.
CSW 10, 10, 11, 12, 13, and the IO. Four doctors, 10, 11, 12, 13.
Who has exhibited some document?
Even Lordship, what I have learned from it, that the injury report is not there. Injury report is not there.
The 20, so I'm granting you liberty to file an application on a 311. Go and try your luck. But I can't direct that if you apply, it should be allowed because I don't know the stage.
Lordship.
আয়ও তো ওরকম স্ট্যাটাস রিপোর্ট ওই জন্য চেয়েছিলাম চলে আসুন
Lordship, may I let there be another direction to file, upon the IO to file the status report.
আর স্ট্যাটাস রিপোর্টের দরকার নেই। They're giving a file application under section 311 না।
আর কি এর বিষয়ে কেউ অর্ডার দিতে পারবে না।
First, otherwise তো judge will change.
চলো, petitioner approached the AS court at a stage when some of the witnesses were not examined. Learned advocate appearing aiming for the petitioner submits that the issue relating to grievance is that CSWs 10, 11,
12, 13,
12, 10, 11, 12 and 13 were not examined.
and the IO.
Who were doctors.
Who were doctors.
Full stop. At the relevant stage also, the investigating officer of the case was also not examined. Subsequently, AA, with passage of time, on 24th of March 2025, the examination of the accused persons under section 313 CRPC was over. And thereafter date was fixed on 25/4/2025 for arguments of the case. So, Mr. Chakraborty appears on behalf of the state. I have considered the agony expressed by the petitioner, who happens to be the de facto complainant. Having considered the stage of the case, since arguments were already are presumed to be heard already on 25th of April 2025. I direct that in case the judgment till date has not been delivered by the trial court and an application under section 311 of the CRPC is preferred by the petitioner, the learned trial court would consider the same in accordance with law. Points of justice. With the aforesaid observations, CRR 219 of 2025 is disposed of, sir. 12 years. কি করে সরকারি সাক্ষী আসেনি?
Additional court, the learned judge stated that best available witness of this case has already been. So that now.
That's a perception. Medical documents doesn't go into evidence.
It's a mechanic. Work out paper, otherwise we not affected the what
So basically,
contractual bank.
কি conduct?
60 মিলত item 6
হ্যাঁ
next time next time তো 59 হচ্ছে
এটা কত হচ্ছে? এটা 60 অপোজিট
এটা
পার্টি
first
নাম্বার
time.
2 কি আছে? মামলা তো হয়ে যাবে তো। Why have you come? কেন?
Not to the next time মানে the copy is not received defect complaint the first time again
De facto is ready to do the case. You are ready? ওই দেখো
next
he is something. Learned advocate aid for the petitioner place for an accommodation. Learned advocate aid for the state is ready with the case diary. However, the de facto complaint opposite aid party number 2 prays for an accommodation on the ground that the copy of the revisional application is not available. Consequently, the revisional application and the consequently the revision application is directed aid to appear before the next available circuit bench. চলো তো শেষ করে আর একটা জাজমেন্ট দেবো আজকে।
I'm appealing for the petition.
Yes.
So this matter was taken up yesterday. Your lordship had asked for the case diary. See the 164 statement of the victim.
Yes, who is appearing? Mr. Mishro, Mr. Chopur. Where is he? You know.
Pass over, lordship.
Passover, কখন পড়বো Passover? order দিতে হবে।
This matter, the opposite party number 2 had a love relationship with the petitioner number 1. Thereafter, the opposite party number 2.
Very party in the case, but he is not, you just throw away her, তাই তো?
Yes. After that marriage, registry marriage took place. Thereafter. No, that is a fault.
Then they will change the sections and trial will go on. তাহলে কি হবে আর?
How
Case
can
is made.
376 lie after marriage?
376 will not lie, but other section 498 will lie.
That they have lost fresh.
But there is a case.
Fresh FIR.
They may be not fresh FIR. Why? You, during the pendency of the case, if you make a representation and try to obtain an advantage or benefit out of the situation, so if you take up this point, it's regarding the applicability of the sections. But offense is made out. There is a difference between offense not being made out and applicability of a particular section.
So we are always ready to bring her as a wife,
that
but
will
she
take
is
you-
refusing to stay as.
370 তে কম্প্রোমাইজ হয় না বলে দিয়েছে সুপ্রিম কোর্টে। কি করবে? পড়বে না নেক্সট সার্কিট? নেক্সট সার্কিটে ভালো জজ আসবে। চলে আসুন। Learned advocate aid appearing for the petitioner as well as the private opposite party is present. However, none appears on behalf of the state. Let the revisional application and be listed before the next available circuit bench. আর তো সময় নেই, কি বলুন? রোজ 80টা করে মামলা করে আমি কালকে ভাবলাম যে কমিয়ে দিলাম, কিছুই কমলো না দেখি। কি করবে? Yes. Hello. Yes.
My lord, washing of FIR.
Yes. FIR, chalo.
Complaint lodged by.
Who is for the state?
I'm for the state.
My lord, complaint lodged by one of the co-sharers of the property against the bona fide purchasers. He has also instituted a civil suit, a partition suit, praying for the cancellation of the
Very
decree.
good.
My lord, my only submission is if he has the right to sell is the subject matter of the civil suit. So my lord, until and
You
unless.
are purchaser only.
Yes,
You have made an accused.
yes. Lordship, may kindly see the FIR.
How many accused persons are there?
18.
The owners are accused. The person who sold you is an accused.
Yes.
তাহলে একে accused করে কি হবে? Yes, Mr. Ghosh. I need for.
Charge sheet has been filed.
No, charge sheet has been signed.
Millard, the only Millard substance of allegation is Millard, the notarized affidavits which was presented showing the legal heirs, that in spite of knowing Millard the next door neighbors, they've absolutely misrepresented, forged the documents. And Millard induced the sale. That is Millard the allegation.
They are the purchaser of the property.
Yes,
Next to.
They are next door neighbors.
yes, all of them.
Millard,
The
my
sellers,
instruction is
purchasers,
not
it's
that. They are
absolutely
not
a collusive transfer.
কত বিঘে জমি?
I will, the charge sheet has also been
No,
filed.
charge sheet submitted all right, but usually what happens is that if there is a power of attorney holder or a particular vendor who has misrepresented and solely aid to somebody, and without being aware of the facts and circumstances, somebody purchases the property.
Yes.
So,
But this is not a case. That's what we have made out in the FIR. Well, the allegation is
Millard, the
Millard,
FIR does not say that we are
Millard
next door neighbors.
only to.
where is that FIR?
Millard, this certified copy, Mal. It is just after.
You got a case diary, Mr. Chakraborty, you are paying? Case diary? नहीं case diary থেকে পড়ি। Legible case diary? Legible case diary?
Yes, yes. This is the deed, my lord.
FIR.
This one is first.
কারা আছে? রাজু সরকার and others.
Raju Sarkar, Nirmal De, Kamal De, Probir Bishwas, they are the purchasers. And 5, Sajjad Hussain is the person who identified the executors. Ashwin, may kindly appreciate whether there is any angle of criminality on our part. FIR এ তা।
You are Subhradeep Das.
Yes. This is absolutely a collusive transfer to deprive me of my rights for the purpose of the partition.
Yeah, my father. And elder brothers of my father name.
Extension change. আছে ওখানে allow আছে।
সবাই ছেলের বাচ্চা পাশে বাড়ি সব, হ্যাঁ। তিরিশ 4/2025। (187 of 2025). New supplement bill of fare.
Which deed Subhradeep Das's name was appearing?
His name, Millard, has been illegally omitted. Despite the fact-
Where is it appearing that it has been omitted? Where is that document?
Look at
That is
the,
deed, my lord.
the deed through which it has been
the
conveyed.
very,
Now
very,
he has claimed, he has filed a suit for partition. Where he has claimed himself as a owner of the property.
no, but he says illegally has been omitted. You see the language you use over here in the FIR itself,
Yes,
removed my name in the original deed.
yes.
The original deed must contain the name of Subhradip Das.
No, original deed means the deed which is in question, my lord, this deed,
The deed of sale.
deed of sale.
The allegation is that he was not included as one of the
He
vendors.
is a legal year, his name has not been.
So that's a joint property.
Yes, joint property.
So who sold it? Actually, relations.
The
Relation.
The other legal heirs, excluding my name, has transferred the property.
The beneficiaries are who?
Beneficiaries are Mr. Chatterjee's clients who are paying for quashing, the buyers. The buyers are also our
How come the
relatives.
buyers are?
The beneficiary are the family members.
The family members, that's exactly the case. here. And it's in connivance, only to
What was,
deprive me.
very good. What was the market value and what did they pay? They will be very.
We have paid 48 lakhs.
No, whatever you have paid, whether that's a market value, you can have 5 crores property at 48 lakhs. I'm not bothered with. But I want to see whether beneficiary means beneficiary to that extent that somebody has knowingly purchased it at a lesser value.
Milord, so far as the registered deed is concerned, Milord, the assessed market value has to be reflected. What was the actual transaction? Nobody
That
will know.
cannot, we cannot,
No, but that is usually more than what is.
Much more, usually much more.
Milord, page
But here we
46.
don't know what was the actual transaction value.
Page 46, the market value has been shown
That's a
as,
circle rate.
yes,
That is a
40 lakhs,
circle rate.
52,000.
Yeah, that's a circle.
And we had the consideration paid here is 48 lakhs. 48 lakhs.
So I'm just assessing it from the angle of the purchasers.
40 lakhs, 52,000.
I'm not that deal is.
Whether there is any color of sham transaction.
Yes, there's
And let's see Annexure B to the
48 lakhs.
application, the affidavit,
48 lakhs.
which
is the
they have
market
prepared.
value. This is the
Both
market
are.
value. This is the two, if you add these two, then it will be.
Fine.
48 lakhs.
Yes.
Much less.
So if for market value, somebody has purchased the property, why should he face a criminal? Irrespective of the fact somebody else has received the money.
No, Milord, the case is unique in the sense, Milord, one of the legal heirs, that is the de facto complainant, Milord, deliberately to exclude him from the family property, this transaction was orchestrated.
The transaction was orchestrated. Very good. Because of the transaction, some relations were benefited by receiving money. Accepted, they have committed the offense. But those who have purchased the property, if they have purchased at the market value, how they have deprived?
That's exactly the subject matter of trial. Because whether there was any consideration, prima facie, there
They
is no.
could have been a
mention
witness to the case because Sajjad, there is a person called Sajjad Hussain who have introduced themselves. How come? I just want to know how come they
today.
become.
So far as execution of the deed is concerned, it is undisputed. It was executed. But whether there was a real transaction.
That
of money,
finally, whether their title will remain or not, that's a separate issue totally.
separate issue, and whether
Civil court will decide that.
from the purpose of
But so far as
criminality,
criminality is concerned,
whether there was, Milord, an actual transaction, that is, Milord, subject matter of trial.
the actual transaction, the deeds have been there, the investigating officer has done that.
But whether money has been transacted, as rightly pointed out by your lordship, that has not been ascertained
But
yet.
that is not your case also.
Then how would they
That is
be
not your
registered?
case also.
Milord, my allegation is there is a conspiracy. Now, how the conspiracy will be proved
Memo of
or
consideration.
disproved, Milord, that is subject matter of trial. And today charge sheet has been filed. They have their remedies.
My lord, I've annexed the money receipt. They're all bank transactions. Page 32 onwards. Memo of consideration.
फालतू trial है ये.
Milord, kindly have a look at page 57.
Yes, 57 is an affidavit affirmed by those relations declaring only themselves to be the legal heir, and we acted upon that. That they are the only legal heirs. 57.
Just 1 minute, sir.
My lord.
Where from are you saying these are all bank transactions? Check numbers.
The check numbers. RTGS transfer, check numbers.
Page 57 is what you wanted to show, Mr. Ghosh.
Milord, the affidavit which was sworn, 57,
The affidavit was done by whom?
The relations.
the relations.
তাহলে আর ওরা কোত্থেকে আসে? That is what I am saying, sir. They have paid money for purchasing a property. I could have understood for 5 rupees if if they had purchased a property, that was a sham transaction. The issue relating to conspiracy would have come. Nothing issue. Now the beneficiary are your relations.
Yes,
Huh?
their relations also.
What?
আমাদের relation group.
The
I
next door
don't-
neighbors. May not be blood relations, but next door neighbors.
48 lakhs have not been, they have parted with that. The relations of the de facto complainant have accepted that, omitting him as one of the beneficiaries. That's your main grievance, basically.
Right.
So how are they involved over here? Criminality with them is involved.
So Milad, I am a person, Milad, the entire locality knows I belong to that house. I have stayed there for a considerable period of time. Now, while purchasing the property, the person who is a next door neighbor, is it not, Milad, a commonsensical scenario that a person of that house, the boy of that house is being excluded and the DD is being
It's long,
excluded?
from 2011, when was the transaction taking place?
23.
23.
23. You last claim your father expired in 2011 and you were thrown out in the year 2006.
Milad, that's the statement. That's the statement. But off and on, I visited the house.
It's his statement, my lord.
Your statement, sir.
Milad, I was.
Your statement in
No,
the
no.
FIR.
No, Milad, my statement is there.
In the FIR.
Yes, I was not allowed to enjoy any Milad,
from
the
2000
household or whatever.
From 2006 onwards.
They have not allowed me any Milad.
Whatever, did not have any access.
I had access. I used to visit, but I was
So,
disallowed. Milad, I was disallowed from entering the house.
Where is that statement? Show me.
Milad, that is not there in the FIR. Milad, now charge sheet has been submitted. But FIR is not the encyclopedia. Let those facts come in the trial.
To show me from a statement, sir.
Milad, that Mr.
Page number 57 in the affidavit, if my lord see the last serial number 9, that is late Shambhudas. Shambhudas is the father of this OB number 2.
57.
Is there, but here I don't know. I think he has been shown as an unmarried. 50.
So those has
তাই
been,
তো করেছে।
those have,
57, my lord, page number. Last is the.
of the charge sheet or the petition?
No, of the main petition.
Of the application.
Application.
Yes.
Lastly, my lord, late Shambhudas, son of late Dinesh Chandra. This Shambhudas is the father of the OP number 2. So his name is there. If they say on the basis of this affidavit they have purchased the property, then his name is there.
No. I am not on their purchasing of that. Their title may not remain in future after civil court passes article. Now, criminality is an intention. You try to appreciate if they have paid proper money, they are not beneficiary of the money. They have got a property in lieu of money. If the market value of the property tallies, why will this person suffer? I have got nothing else to say. If I could have understood that for 15 lakhs, they purchased a 48 lakhs property, you had a case. Conspiracy angle or intention angle would have definitely been much more expressed. Now, if they have purchased a property for a market value, I again repeat, and the money has passed to some other persons, because if you have been deprived of that money, you have come to court. Basically, what you are wanting is your pie of that 48 lakhs.
Yes.
It's a simple thing.
Yes.
Now, how are they responsible for that? That is what I want to know.
Milad, our only Milad case what we have made out from the FIR and in the Milad in our complaint is Milad, it was an orchestrated transaction.
How orchestrated? Orchestrated means every vendor will try to find a seller.
No, Milad, it's unbelievable, Milad, that a next door neighbor will not know that late Shambhudas, whose name is mentioned as pointed out by Mr. Chakraborty, his son is somewhere there. And he is not included in the deed as a party, as a beneficiary. I mean, the circle rate has been transacted through banking transactions. Now, whether that money has actually flowed, whether the checks have been actually encashed, no one knows. There's only one RTGS transaction. And we don't know whether that money was...
Rest all checks, sir. There's a check number.
Yes, but whether the checks have been encashed, whether they have actually received the consideration, no one knows.
That is not the case of the prosecution also. I understood
Milad,
that
that is the subject matter of trial, probably.
That those
How the
parts,
prosecution will try to prove, Milad, that there was an angle of conspiracy, that is a subject matter of trial.
not less.
Milad, now a charge sheet has been filed, a prima facie offense has been made out. Milad, let them face that trial. Or let the learned law court consider on the basis of materials whether they are entitled to discharge.
Sir, had it been those beneficiaries coming in, I would have said like that. Immediately I've said like this. These are persons who are, these persons are.
So whether they're bona fide purchasers, that is the question.
And they are bona fide, their money is from illegal.
Check.
sources.
And now, so far as the circle rate is concerned, it has to be in checks. There was no other option for them. If a deed has to be executed, there has to be the circle rate paid. And it has to be through banking channels.
This person, Sajjad Hussain, sir, he'll face the trial.
But he identified.
At identified, you have played a
those who
role.
Presented themselves as the
Owners.
owners. That's
So
all.
he has a role to play. Yeah, so far as this Shorkar, they and Biswas are concerned, no case is made out. He is not a purchaser.
No, Sajjad is not a purchaser.
He identified.
That is an admitted position.
So far these 4 persons are concerned who are the buyers of the property. Benefit can, Sajjad Hussain is concerned, he has a different role to play altogether. I have got no issues. He has got to
But
play.
had it not been next door neighbors, I have no case. Practically, I have no case. Because they're next door neighbors, they know the entire family. Now, how this deed can be executed?
They can't say criminality cannot
Well,
be.
let them face the trial. What is the difficulty, Miller? There is a deed executed, someone has been deprived from his property and Miller.
That is between inter-se between the relations.
That's right.
That's
There's a
inter-se
color of civil dispute, undoubtedly.
That is between the, I'm not entering into that zone. Inter-se, if the deprivation was there, they did not deprive you. They have purchased it for proper.
Miller,
Deprivation is by the relations.
at this stage, Miller,
At this stage
conclusively,
only.
Miller, at this stage,
Now that
conclusively, whether they were not a party to it, Miller, probably there is no material before Lordship to conclusively arrive at a finding that in no stretch of imagination they were a party to it. They were not a party to it.
So what should be a stretch of imagination?
Miller, let them face
some
the trial.
bystander.
Miller, let them face the trial. Let the witnesses come. Let them adduce before the court.
What they will adduce, sir?
But whether they were party to it, whether they knew about it, whether they knew that someone is being intentionally excluded, whether there was a real transaction.
Even if it is intentionally excluded. Suppose, let us presume the worst case, intentionally excluded. So what business they have got to do with that, sir? Until and unless there is a case made out by the prosecution that you have made out your case. Because you are the de facto complainant. You have thrown out whole of the society. Now it is for them to sieve out who is an offender and who is not an offender. Now, it's their case because you have, now the issue is that until and unless they are able to show, there's a investigating officer's duty that for a cheaper price, they have paid, they were out of a deed transaction. And now I am not entering into that zone also. I'm only saying this is the market price, whether they have paid or not. Nothing more than that, sir. If that is the price, the buyer, in any case, whether they were neighbors, whether they were not neighbors also, irrespective of that, as a matter of principle, they should not suffer the ordeal of a criminal trial.
Millard, today, Millard, at this stage, probably we don't know how far the prosecution will be able to go. Let them give let us give them a chance in the trial. How far they can go, how far they can prove the angle of conspiracy.
Earlier, those theorems were there. Now, Supreme Court says, if an appropriate case, the High Court doesn't exercise its powers under Section 482, then the High Court will be committing an error.
No, Millard, the test is abuse of process. Millard, whether this will be at this stage, Millard, a clear case of abuse of process subject to correction, Millard, my response will be no.
You tell me.
Subject to correction.
No, not a correction, sir. Subject to admission.
Millard, there is a FIR which says that this was a part of conspiracy. There is a affidavit, admittedly, where Millard, a person's name has been wrongfully excluded.
That is why that is why petitioner number 5.
Yes.
Petitioner number 5, I have said already that he will be facing.
He has to probably the sellers also. Now, probably the sellers should also face trial.
Why?
The sellers, Millard.
Sellers.
The sellers of the property who has caused this affidavit to be
That is something else. Sellers are not before.
Millard's only
I am only
concerned
for the
about
buyers.
the purchasers.
Purchasers, yes.
Now, Millard, whether there is a conspiracy, Millard, how at this stage it can be concluded that there is no color of conspiracy. Next door neighbors.
Tell me how you address them.
Millard, next door neighbors, unbelievable that I don't know that late Swayambhu Das lived in this house. He was married. He had a son, and his son is not there.
Very good. Then you tell me that first of all, his money is so precious. You understand? No. everybody, to you also, huh? Now, had they got it for a cheaper price, I could have understood easily. I've got no issue that you, had it be in some,
But today, what is before your lordship is
whatever is
payments,
before me.
is prima facie proof of payments of the circle rate. Now, what is the market rate? No one knows. Maybe
Even
that will come up in the trial.
Registrar's office, my lord. So then 319 there, but at this stage, 319, you add them. I'm granting you liberty at this stage. They are not required
Millard,
under
Millard
section-
reserves that liberty for me, Millard.
at the appropriate stage, if evidence surfaces against this
Great,
petitioners,
great.
so far,
Grateful.
under section 319
Grateful.
of
Grateful. Millard reserves that much of liberty, Millard, I'm grateful.
Obliged.
I think case.
And so far as 5 is concerned, my lord, he is not a purchaser. He identified those who presented themselves with their credentials at the time of
Credential
registration.
there is a wrong credential, a person, particularly what he has pointed out, the part, he was a witness, basically dalal. হ্যাঁ, যে ডিলটা করিয়েছে তুমি ফেস করতে হবে ট্রায়াল, যত ভুল ভাল জমি জমার কাজ করাবে, কি করে দিই না কাল করবো
As your lordship, as your lordship did that.
এই ডিসিশন আই হ্যাভ টোল্ড ইউ
No, no, no. Tomorrow, Millard, we won't be arguing if lordship passes the
These
order.
four petitioners, or I can pass it, কালকে টাইমও নেই
then your lordship
টাইমও নেই. Today, the other persons will be deprived, sir.
But
There are
and-
other matters also.
Subject to your lordship's approval, the hearing is concluded. Let your lordship exhaust the list. I'll wait, my lord.
No, there is one, you have another matter tomorrow.
Yes, yes.
Difficulty, whatever, at 4 o'clock, I'll be dictating that matter of Mr. Chakraborty and Mr. Bhomik.
Yes, yes, yes. Then, my lord, tomorrow?
Tomorrow I'm keeping the matter. এটা শেষে দেবেন, 4টের সময় দেবেন, আমি ডিকটেশনটা দিয়ে দিতে পারবো। সকালবেলা দিয়ে দিলে ডিকটেশন দিতে পারবো না এটা। Tomorrow at 4 PM I'll pass the order.
No, 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 no difficulty.
এটা for orders 4 PM লিখে দিন। হ্যাঁ, কালকে 18। Tomorrow I'll pass the order. Take some time, other persons will be deprived. Case diary be retained along with the records. Next. Yes, Shabodar. What is there? Your case, the matter needs to be heard on merits. Petition is. আর কি করতে ইচ্ছা আছে না নেই? হ্যাঁ? Next circuit. Say.
My lord, please circuit, my lord.
Huh?
Not next circuit, my lord. Small issue, my lord.
What is the issue? Judgment and order dated 1911 passed by the
My lord,
judgment
issue
is
that, my lord. I filed
CR
an
case,
application, my lord. There's a case counter, both
138.
138 against me. And my
Yes, sir.
contention that, my lord, by forcefully, they signed the check. I also lost the written complaint, which was registered and charged is submitted, my lord.
যত বাজে মামলাগুলো করবে যাচ্ছে। What you are an accused in which case? 138 K. And yours is this is quashing of what? For adding both the cases. You have been successful convincing the police authorities or yourself CR case? CR case? Police case? আরে বাবা, হ্যাঁ কোন থানা? হ্যাঁ? এই যত ঝামেলা দিনহাটাতে আমি তো what is your prayer? That is the same person, if he does 420, then it can be done. আর কি করে হবে? আর কিছু নেই, এই ছোট করে করে দিয়ে এগুলো করে দিই, নাহলে পড়ে থাকবে মামলা। এই নান অ্যাপিয়াজই হবে প্রত্যেকটা সার্কিটে। When I will become this say that 6, that is why I have kept them. In the 138 proceedings. ও ঠিক আছে, ওগুলো যা হবে হবে, আমি আচ্ছা petitioner is agreed by the order passed in criminal division number 6 of 2024, wherein the learned additional sessions judge Dinhata. After considering the contention advance on behalf of the petitioner, was pleased to dismiss the revisional application. Records of the case reflects that on 10/9/2024, learned ACJ AM Dinhata passed an order in connection with CR case number 105 of 2020, which is a proceeding under section 138 of the Negotiable Instruments Act, initiated at the behest of the opposite party number 2. No, opposite party number 1. You are Arjuma Bibi. বিরাট খেলে দিয়েছে, এই চালাক ছেলে তো চুপ চুপ করে থাকে, হ্যাঁ, পার্টিটাকে চেঞ্জ করে দিয়েছে, হ্যাঁ। দেখেও নিতে হয় আমাদের যা অবস্থা। আচ্ছা, the prayer which was advanced, where is your application 210? The prayer which was advanced by the petitioner was 17, which was advanced by the petitioner was for clubbing. The complaint is number, CR case number কত আছে? 105. হ্যাঁ, 105 of, হ্যাঁ, 5 now. 105 of 2024, along with Dinhata PA's case number 471 of 2020, dated 9/12/2020. আরে এই চেকটা পরের গন্ডগোল। 105 of 2020। No, the complaint case number 105 of 2020. Okay. Since the complainant of the proceedings under section 138 is the accused in Dinhata PS case number 471/2020, the learned magistrate refused to entertain such prayer. আরে বাবা, ডাবল জিওপার্ডি ফাটি সব দিনহাটায় হচ্ছে, যাই হোক। হ্যাঁ, আর the said order was challenged before the learned session, learned additional sessions judge Dinhata, which was again refused by the by the divisional court in criminal division number 6 of 2024. Full stop. Since there are concurrent findings of the trial court as well as the learned divisional court, I'm not inclined to invoke the inherent powers of the court, as I do not find any illegality in the impugned orders. Chalo, with the our direction, this has got nothing to do. Tale, you will also face that. With the aforesaid observation, CRR 5/8 of 2024 is dismissed. Any application, if any, is constantly disposed of for them. So next. So you have gone to the divisional court? এতগুলো কোর্ট করলে হয়? দেখি কি বলেছে। এই পয়েন্টে আমার জাজমেন্ট আছে, কিন্তু দিস ডাজ নট অ্যাপ্লাই স্যার। এইসব শিয়ালদা কোর্টে ভর্তি হয় এই মামলা, রেলওয়ে স্টেশনে চেক দেয় আর সব যে যার মতো ব্ল্যাঙ্ক চেক দাঁড়িয়ে থাকে, টাকা সুদ দেয়। It was denied and the duty of and the body of the checks in question was not filled up by him. Was it by someone else and if so the petitioner. না, এটা আছে তো, মিঠু ঘোষের কেসটা আছে, একটা কেস আছে, আমি করে দিয়েছি ওটা। That's on the basis of Supreme Court judgment, in fact. Even if the color of the ink doesn't match, the until and unless the factual circumstances are rebutted to the extent that there is no discharge of debt or liability. Huh? So you first prove that you had no liability. Yeah. At this stage হবে না, হয়তো হবে না। Only you have taken up a plea, না? plea তো সবাই নেয়। আর কি প্রথম দিনেই ছেড়ে দিতে হবে, আই এম ইনোসেন্ট বলে। চলো না, না কিছু নেই। So what's your conclusion of trial? At which stage? Before 313? Before 313? When they have filed this? হ্যাঁ, DW তে কোথায়? DW তে কি দেখিয়েছে? এভিডেন্স আছে দেখি। Date fix for DW means in evidence what have you stated? এসব কিছু মামলা নেই, এগুলো সব টাইম কিল করা হয়ে গেছে তো অনেকদিন। কোন সালে মামলা? ইস, তো 5 বছর হয়ে গেছে, আর না, আর হেনস্থা করে না। এক্সপার্ট এই না, সিগনেচার হলে দিয়ে দিতাম। Contents of blank checks, so that blank checks admitted from 1992 Supreme Court. Huh? So you have got to you have got to show, sir, the transactions. And you have say as a petitioner has page 16 না কোথায় অ্যাপ্লিকেশনটা? Petitioner preferred an application before all the learned aid ACJ AM Dinhata in connection with CR case number 108/2020. They were praying for examination through the expert for assessing the writings in the check. So far as the contents of the check are concerned, although the petitioner do not dispute the signature in the check, তাই তো? এটা ভুল পড়ে আসেনি, সিগনেচারটাও চ্যালেঞ্জ করেছে, পিটিশনে লেখা আছে। আচ্ছা, such prayer was turned down by the learned ACJ M. Dinhata. Again, such rejection, petitioner preferred criminal division number 4 of 2024 before the learned aid additional sessions judge. Criminal division 4 of 2024 before the বুঝতে পারছি না কোন মামলায় কি দেখাচ্ছে আমাকে, বলবো পাল্টা জেরক্স কপি। একশো 4 বললাম না, 108 বলছি তো, সিআর কেস আমাকে 108। আর তারপরে লাস্ট এখান থেকে প্ল্যানের অ্যাডিশনাল সেশনস জাজ দিনহাটা। আমি না বললে তো জানতোই না। কোর্টে এটা কাজ নয়, কিন্তু ডেলিনকুয়েন্টকে হেল্প করা কোর্টের কাজ নয়। তো দুটো কোর্ট করে দিয়েছে, কনকারেন্ট কোর্ট তো ফাইন্ডিংস আছে, আমি কি করবো? Inherent the palpable illegality you have got to show. মক্কেল বলেছে তো এটা। তো শুধু হাতে আসলে কি করে? কল্যাণী ভাস্করের জাজমেন্ট এনেছে, কল্যাণী ভাস্করের জাজমেন্টটা কোথায়? আর হাতে করে জাজমেন্ট নিয়ে আসতে হবে, ওইটুকু খাটতে হবে মক্কেলের। আর নয়, অনেক 5 বছর হয়ে গেছে বেকার সাফার করছে এরা। দিনাটা খুব ঝামেলার জায়গা, আমি এটা বুঝে গেছি। এই যে আমি না না, আর একটা জিনিস হচ্ছে যে খুব ক্ষমতা আছে, গিয়ে ওই কেস পুলিশকে পিএস কেস টেনে দিয়েছে। দিস পিএস কেস টেনে দিয়েছে এটা। হ্যাঁ, no, no, but he has gone to the police station and police station and registered a criminal case. That is what surprised me. He's a bit powerful person over there in Inata. That primary school teachers are dangerous, you know. They hardly go to school and they are available where you know. চলো, হ্যাঁ এই হলো। Inata. The learned sessions court on an appreciation of the material so placed and the fact that the said application was taken out before the trial court at an advanced stage of the trial after the examination under section 313 of the Code of Criminal Procedure was over. একটাই দিতে পারি, আছে এভিডেন্সটা আছে সামনে। ক্রস এক্সামিনেশনে ফার্স্ট ক্রস এক্সামিনেশন নেওয়া থাকে যে সিগনেচারটা আমার নয় তবে দেবো। হ্যাঁ, ওসব নেই, ওসব unless if you are dragging the matter. না, you tell me one thing, with one answer. This revisional application got admitted on 23rd of December 2024. Very good. The revisional application before the sessions court was disposed of on 21st of November 2024. So from 21st of November 2024, we are in June 2024. There is no interim order of stay. Right? The trial court till date, why it didn't deliver the judgment? You tell me. তাহলে কিন্তু এনডিপিএস ও বিল পাবে না নভেম্বর থেকে, যারা আটকে আছে আমি বলে দিচ্ছি। হ্যাঁ, সব জায়গায় from November there is no interim order and you have what is left in trial? DW stage এই application file করেছে, আরে আফটার 313 তো, তাহলে আবার এমনি হবে, আমি বুঝি আরো 2 বছর এমনি টেনে দেবে, এখানে ফেলে দেখে কোনো লাভ নেই। বলো কি বললাম? একটু আরেকটু আগে দিয়ে full stop. Since there are concurrent findings of the court below, and the application has been aimed by AL to delay the proceedings. As also the fact that from the inception in the cross-examination, such issues were not canvassed. The sessions court order doesn't reflect that, sir. Show me. See, after the defense evidence was closed, last check, and also that and also the application was preferred After the evidence of DW was over, I am of the opinion that the courts below did not take an incorrect view. Accordingly, I am of the opinion that no interference is called for. Thus, CRR 509 of 2024 is dismissed. Chalo. যাও, অনেক হয়েছে। Next. Cancellation of bill এখানে চলে এসছে। 60. Very good. What is the issue of cancellation? In bail. Where is the bail order? 66 দেখি। Yes, Gazette is there. What is the injury report? After how many days bill was granted? After how many days of arrest? And legs. Abrasion. Charge sheet submitted, sir. Submitted. After when was this person arrested? এর নাম কি? এর নাম কি 24 সেপ্টেম্বরে তো কে? না, নুরুল হাসান। চারটে হতে আর একে who is the accused in this case? Second Afijul, Ichub Ali আর এ they were granted anticipatory bail. Where is that? देखिए what are the anticipatory bail देखिए. Where is it? 25/10/2021.
Has already been granted bail in the constitution of include Muhammad Fazlul. Present execution also will be granted.
These strong petition in the brief and submitted their statements of the wrong and the witness. The name of the actual, if further submitted, the victim was brutally assaulted, for which the victim sustained serious injuries. So why are you doing this case first? First the bill order was obtained. The bill order was obtained, the person was in custody for how many days? Riyaz is all these matters are for anticipatory bail. It has been as a case, but in respect of the year and other matter, I think it refers to the Abdul Bakar Mitubali and they are of in respect of the order which was passed in October. Or the and that this October order, so earlier bill was passed. Earlier bill order was passed. Earlier bill order. So that is 65. That is and November. This is the earliest order, 2510. Where is the statement of the victim injured?
It's 7, page 28. Page 28 and 7 in what? I have also
DNA. এটা কিছু বুঝতে পারছি না, এরকম হাতের লেখা দিলে বোঝা যাবে? What is the name of one Lihaj Hussain? Yes. থেকে পালিয়ে যায় বর্তমানে আমি That's a different. Except Lihaj Hussain তো কারোর নাম নেই victim statement এ, হ্যাঁ? এসে মাছ দিয়ে আমার পায়ে Sir, except Lihaj Hussain, nobody is there. According to statement of the injured. FIR is not by the injured. He said that this is 22/10/2024 statement, sir. That is much later than the FIR. And there he specifically stated again Lihaj Hussain, wherein he said that he is the only person who assaulted with a bamboo over his hands, legs, and different parts of the body. No other person has been named, and on hearing his hue and cry, different persons came over there. As such, they fled away. What more is required, sir? What, this is enough? Order which has been passed in 25 November 2020. Yes, a regular order which speaks. Considering all the aspects, the expectation of the state, that would be No, that is not, sir. Learned public prosecutor Jalpaiguri raised from the middle. Learned aid public prosecutor Jalpaiguri raised strong objection against the prayer for antecedent and submits that there are statements of the complaint and other witness which discloses the name of the actual assailant. He further submits that the victim was brutally assaulted for which the victim sustained grievous injury and his treatment is going on. On the other hand, learned defense counsel that the present accused petitioners were not at all involved in the alleged incident and they were falsely implicated to harass them. Having regard to the submission made for both the parties and consider the nature of allegation and also on perusal of the materials available in the case diary. Materials available in the statement of the injured, sir. 25th of October, the statement of 22nd of October. চলে আসুন, অনেক হয়ে গেছে, ক্যান্সেলেশন এর বেশি হয় না। Learned advocate appearing for the petitioner submits that there is perversity in the order passed by the learned vacation judge, learned judge, which is learned vacation judge Jalpaiguri in the order dated 25/10/2024. আরে এটা which police station এটা? হ্যাঁ, ওরে আলো, ওরে বাবা, স্টেটমেন্ট করিয়ে পাঠিয়ে দিয়েছে কেস ডায়েরিটা। হ্যাঁ, এফআইআর থেকে জজের কিছু করার থাকবে না। হ্যাঁ, কি বললো? Passed in criminal miss case number 1901 of 2024. এটা না একটু দেখে নিয়ে না বললাম কোন এবারে 66 একদম 66 দেখুন, হ্যাঁ, তারপরে 65টা দেখছি একই হবে মোটামুটি, কিন্তু সিআরএম ফিআরএম গুলো পাল্টে দিতে হবে। হ্যাঁ, learned advocate aid for the petitioner submit is that no reasons have been assigned by the learned sessions court while passing the order of anticipatory bill, and as such the CAAM should be cancelled. Learned aid advocate additionally, it has been submitted that the Boreralo police station is segregating which police station? না না, ভক্তিনগর তো প্রধাননগর ভেঙে হয়ে এনজিওই বাজে পুলিশ স্টেশন, কিন্তু লোকটা কিন্তু খুব মার খেয়েছে কিন্তু। I've seen the injury report doesn't match with the 161 statement. I understand, but even if we understand, we can't do many things, sir. There are many things when we are not happy also, but even if we are not happy, we are bound by the structure of the law and we have got to move by that. I've seen that. কি বললাম? Under 226, you pray for transfer of investigation. Otherwise, the criminal court, while acting as a criminal court, I'm acting as a statutory court. Try to appreciate it. But while acting as a 226 court, I will act in as a court which has unfettered jurisdiction. কি বললাম? That the injured suffered immensely and was bedridden. The injury reports also reflect the same. But however, surprisingly, without consideration of the same, the learned sessions court granted anticipatory bail. Full stop. Learned advocate aid for the state has produced a case diary and drawn the attention and drew the attention of the court to the injury reports as well as the statement of the different witnesses, including the statement of the injured victim. Full stop. Learned advocate for the opposite party number 2 submits that one Liajat Hussain naki. You said that was page number 37 also. No, you say that statement of the, page, huh? Yes. 28, now ঠিক লিহাজ হোসেন মানে ওটা মজারুল এর নাম কি লিহাজ হোসেন আচ্ছা কি একটু দেখি আবার এফআইআর ইংরেজিতে কি লিখেছি চুপ বদমাইশ থানা 15 দিন আছে একটু টাইট করা যায় না কলকাতায় থাকলে দেখে অবস্থা LIHAJHOSSAIN হ্যাঁ কি বললাম এবার against one Lihaj Hossain, an application for cancellation of bail was preferred. However, the same was dismissed for default. Full stop. I have perused the case diary, and I find that a statement was recorded by the investigating officer of the case relating to the injured victim, who has solely referred to the aforesaid Liaj Hossain as the person who has inflicted all the injuries upon him. The said statement was available in the case diary as it was recorded on 22nd of October 2000 and 24 na 5. Twenty-four, na? 24. Na- 25 by 24. Yeah. 22. Yeah, 26 or 22nd. Okay. Having considered that there was every scope for the learning vacation judge Jalpaiguri to consider the statement of the injured or victim, I am of the opinion that the conscience of the learned sessions was fully available in the application for anticipatory bail was heard by the state court. As such, no interference is called for. Accordingly, a CRM DB 731 of Veto is rejected for the 731 of 2024 is rejected. Kolo. তারপরে আরেকটা কি আছে what is the earlier one 65 কোনটা আমাকে দিয়ে দিয়েছেন 730 হ্যাঁ এখানে আছে এটা নিয়ে নিন 66টা নিয়ে নিন ওইসব is also anticipatory. This is bail. Achha. Bail, this who is the person who got bail? Of course, the present application was referred for cancellation of bail dated 29/10/2024. Which was granted by the learned vacation judge Jalpaiguri in criminal case number 1973 of 2024. The main thrust of learned advocate for the petitioner submits that there was complete non-application of mind of the learned sessions judge while granting bail, and the same was passed in such a mechanical manner that interference of this cohort is called for. Learned advocate for the private opposite aid party submits that prior to the present opposite aid party number 2 being granted aid bail, the principal accused was granted aid bail. Full stop. Learned advocate aid for the state has produced a case diary and referred to the statement of the victim of the injured. I find that there is a specific reference to ও লিয়াজ হোসেনকে অ্যান্টিসিপিটি দিয়ে দিয়েছে। এই 2 সপ্তাহের জন্য এসে কিছু করা যায় না এখানে। আচ্ছা কি বললাম? Anticipatory bail being granted to the principal accused, huh? Full stop. দেখে আমি ঠিক বললাম? জাজেরটাই করছি তো না? Granted anticipatory bail was obtained. আর দরকার নেই, প্রিন্সিপাল অ্যাকিউজ ওই নামটা দিয়ে দিন। হ্যাঁ 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 injured. Now I find the specific reference being made to Diaz Hussain for inflicting injury is upon the injured victim. Full stop. ওই আগে বলছেন। In view আচ্ছা, in view of the opposite party, Abdul Sattar being on a better parity, the learning sessions court granted bail to the opposite party number 2 who has already suffered custody. Having considered the same, having considered the reasons assigned by the learned sessions judge, I'm of the opinion that there were reasons in the order which may not be to the satisfaction of the de facto complainant, but the same cannot be said to be a non-speaking order. Full stop. Further, the said order was passed on 29/10/2024, and more than 8 months have passed. There are no accusations till date that there has been misuse of any liberty by the said accused after he was released on bail. Having regard to the overall circumstances, at this stage, I am not inclined to interfere with the orders passed by the learned vacation judge Jalpaiguri on 29/10/2024 in criminal miscase number 1973 of 2024. Accordingly, CRM DB number 730 of 2024 is dismissed. Cancellation of bail dismiss করা ছাড়া উপায় নেই, allow or dismiss দুটোই তো order হবে। ফেরত দিয়ে দিন, কেস যাই না। এটা ঠিক আছে। ঠিক আছে, পরেরটা 65 হ্যাঁ। Yes.
Your Lordship, in item 67, I am appearing for the petitioner, Lordship. This is my application for extension of interim order.
Extension, where is Mr. Chatterjee?
Your Lordship, I am.
নেই, কোথায় গেল? এটা কি করতে হবে? এই আস্তে আস্তে করুন, আস্তে আস্তে করুন, চাপ হয়ে যাচ্ছে actually। ওরাও তো বেড়াতে এসছে এখানে ভেকেশন। Yes, madam, what are you opposing the extension?
No, Lordship, I am praying for my extension of interim order. Lordship, my interim order
Extension. Who is for
expired
the
on.
opposite party? One week after summer vacation, ঠিক আছে? আর ভালো লাগে না, ওই জায়গায় একটু দিয়ে দিচ্ছি। 15 July, next available circuit. The NP The interim order earlier granted is extended 8 till 15th of July 2025. List the revisional application before the next available circuit bench under the same heading. Later to be under the heading hearing contest, another heading contested application for review. Accordingly, CRAN 2 of 2025 is disposed of. এই আমার লিস্টটা বেরিয়ে গেছে বোধহয়। না না লিস্টে এখানে আছে আছে। হ্যাঁ এভিডেন্স সার্ভিস ফাইল বি কেপ্ট দ্য রেকর্ড উপরে করে দিন প্রথম। 68.
Your Lordship, I am appearing in 68 also, Lordship, same prayers.
Same order. You are there, both of ওই একই অর্ডার করে দিন 68 এ। তারপর দিন কি শুভ আমূল। হ্যাঁ 68 হয়ে গেছে।
Much obliged, Your Lordship.
Who is unwell? করতে চাইছে কোন মন্ডল দেখি? Learned advocate for the petitioner prays for an accommodation. Stay is there. For what vacating? Oh, the excited হবে। Learned advocate for the petitioner prays for an accommodation on the ground of his senior counsel. Learned advocate for the state is present. In view of the accommodation sought for leads the revisional application in next available circuit bench along with the connected application. The revisional application along with the next available. Next তাতে দাও কাজেই কাজ করি। গণেশ কুশওয়া 70 years who is appearing? Yes, Mr. Chakraborty.
Lord, in 70, I appear for the complainant.
Huh?
Certainly not.
Yes, CRPC. Which year case? 2020. Charge sheet submitted. State has not come. But the hearing হলো না আপনার hearing তো করে যাবো একটা। হ্যাঁ কালকে থাক। আপনার একটা ইয়ে আছে তো গ্রিভান্স আছে তো হিয়ারিং হয় না এখানে। কালকে হবে। Tomorrow. Let it be there. If time doesn't, next we'll shift it to next. Not today, again next.
My lord, I beg to appear for the petitioner virtually.
71.
Yes, ma'am.
Is who is appearing? You are appearing. There is a de facto or no, not required.
My lord, the additional districts have registered, my lord, of the Diden, Kuch Bihar. The revisionist playing for the application.
Acha. Yes, so you have a CRAN over here. For what?
My lord, I had filed I have obtained an order of stay of this proceeding against the present petitioner, my lord. That is for extension of that order, my lord. The CRAN. My lord, but my lord takes, I can proceed with the hearing of it.
See that for a deed to be registered, there is a পিসি একটা কেসে সি করে দিয়ে বসে আছে। What is the stage of the case, Mr. Chaudhary?
One of the investigation to some extent has carried out, my lord. I am holding the CD, there are certain 161 statements have been recorded. My lord, may I hand over?
My lord, may I place certain facts that are very pertinent, my lord?
But this is investigation stage.
My lord,
What is the
my lord, I would go to the complaint itself, my lord. I just want to refer to the complaint
Yes.
and the steps taken by the complainants, which shows that, my lord, I am the victim of the fraud that has been perpetrated by the accused persons, my lord. It is not the case that I had any knowledge, my lord. I had no knowledge because the fraud was committed against the petitioner.
You carry on. What is there? Read
My
that.
lord, kindly takes the FIR, my lord. My
Yes,
lord,
I am
in
on the
FIR.
FIR.
My lord, it has been stated, my lord, in my para 5, I have pleaded in the pleadings. On
No,
20,
come to the letter of complaint and read that.
yes, my lord. On 23/8/2021, Parvati Shahu, Rekha Ray, Anakul Ray, Tugin Adhikari, Mukul Haq, Shyam Sundar Ray all came to Kuch Bihar Additional Register Office and illegally registered my 3 acre of land in the name of Parvati Sahu, Rekha Ray, Mahendra Nath Roy. Himself impersonated Mahendra Roy by creating a fake voter ID and registered the entire land by this deed. Now, my lord, thereafter, I gained knowledge of the conspiracy when the accused persons registered the document and the fake using a manufacturing fake voter ID card by Mahendra Nath Roy. My lord, now they have also filed a suit, my lord, for cancellation of this deed, wherein they have pleaded that the registering authority also has been fraud has been committed against the registering authority by these perpetrators. My lord, in the present case, my lord, there are several relevant provisions wherein, my lord, I am not the person who is personally knowledge of the person who is there authorizing the deeds. I have given my best to ascertain if that is the same person. But he has used fake documents in front of me and deceived me, my lord. This is the case. My lord, kindly takes, my lord, the provisions of West Bengal registration deed writers rule. That would be handed over, my lord.
Where from the name of this
May I, my lord?
petitioner
Indicate. It has not come, my lord. What happened, my lord? I am the registrar, sub-registrar, my lord, attached to the Kuch Bihar, my lord, district sub-registrar office. My lord, this accused, my lord, has presented a deed, my lord, and the photographs were affixed, impersonating a person's name. Suppose now, my lord, I am Joyjit Chaudhary. I am impersonation that said that I am X, and my photograph was pasted there. It
No,
was
I'm
presented
just
before
asking a simple question to you.
No here.
Lomin Dolma Lama.
Yes.
She's a registrar.
Yes, sub-registrar.
Whatever, sub-registrar.
Yes.
Her name is, she's not FIR named. So what happened? Why they are agitating this one?
Because, my lord, there was an order of the, my lord, the Honorable Division Bench while considering the 438 application by my lord Justice Bagchi. In the said order, it said for unraveling the truth, even the registering authority should be taken into consideration. And the 17A, my lord, the Prevention of Corruption Act, my lord, these charges were leveled even, and the permission was obtained to undertake such investigation. That permission has come, my lord. And then, my lord, the certain, my lord, the statements recorded, the person from the deed writer and the person who had presented that. From there, my lord, if you lordship see, it has not come even because I have discharged it. Yes, I have discharged, my lord, the duty as a sub-registrar. If someone has come, I do not know. That is the
error in judgment is different from criminal
yes, but
misconduct.
there is no main rea, my lord. I did
But
not
at
find
this stage, the interference is also a problem.
exactly. That's true.
How can I? Because the division bench has passed an order.
Yes.
investigation is being done pursuant to a direction of a division bench of the High Court.
The investigation carried out prior to that.
But so whereas
But so far with regards to the registrar's concern, that pursuant to the direction of the honorable division bench.
So how can this will be reviewing of the High Court's order basically?
No, that is in that is in 438 application.
Whatever it is, but then they have not challenged that observation anywhere.
No, I think so.
I mean, not be.
It has not come in city.
High Court is not the proper authority if another bench has passed an order, because police did not took this petitioner into the account or score of or ambit of the investigation. The ambit of the investigation came in, so as the petitioner is concerned,
the moment the order has
moment the order has passed.
Yes.
So how can I?
My lord, kindly see few facts, my lord. There are very pertinent facts, my lord.
No,
My
no,
lord,
these facts, why
just-
should I enter, sir? You have got to go to Supreme Court directly from that 438 order. How can I do? Because your name is not there in the
My lord,
FIR.
My lord, I have no knowledge about any such order.
FIR, your name is not there.
Yes, my lord, if they don't have, my lord, there is no involvement of me, my lord.
So
My lord,
may I suggest?
And the investigation has not been concluded also.
May
My
I,
lord,
You
I'm-
understand the
Yes,
difficulty?
may I suggest one thing, Miller? Because in these circumstances, Miller, let us carry out the investigation.
I was
Without the leave of the court, Miller, that the investigation report should be. In the meantime, a protection may be given, because if the officer discharging with a person, that may be done.
You see, one thing, you will be facing difficulties if you stall the investigation.
Yes, no one can, Miller. No one can.
I don't intend that, my lord. The investigation is not straight, my lord. Only my lord, I am willing to cooperate with the entire investigating agency, my lord.
Investigation state with regards to the person concerned. So we have to definitely undertake the investigation.
They have got to work on you, sir. Because
My lord,
they
I will cooperate, my lord. I will cooperate to whatever extent.
Otherwise, sir, until and unless they come to a logical conclusion,
yes,
it will be very difficult for another court. At least a division bench is there. Let me see now 438. It's a coordinate bench. Either you had to challenge that order before the Honorable Supreme Court, and you are now asking the coordinate bench to quash that order, which is practically impossible.
My lord, at this stage, my lord, because I am a very,
Yes,
my lord, I have
possible.
just discharged my duty bona fidely, my lord. So, my lord, if I am protected, my lord's order, that I'll cooperate with the investigation, and whatever the fate of the investigation would lead
That
to.
would be better for you, because otherwise.
Grateful, my lord. I am also assisting, my lord, if this could be done. No coercive steps could be taken without the leave of this honorable court.
Miller, kindly produce at least a 161 statement, Lordship.
I don't think any involvement of this. But even then, their PC Act charges are there, permission has been granted.
So investigation is required to be carried out. We don't have any other option.
And the High Court
And
and High Court also, another bench cannot quash the proceedings.
Yes.
Both are there.
Both are there.
So we have got to allow, we will give some protection, allow.
Yes. Let us complete the investigation.
You have not taken bail, no?
My lord, I have approached the High Court directly.
No.
Bail, anticipatory bail, you have not
Nothing,
filed.
nothing, my lord. No, man.
Her name hasn't come as of now.
Then I'm disposing of this matter with a direction that no coercive steps be taken against the petitioner who is a government servant and usually available in office. Number one. Number two, she would cooperate with the investigation of the case, and the petitioner, if so advised, will at the appropriate stage approach before this court. That will
And to
suffice
complete
your
the
purpose.
investigation at the
Otherwise, they will not be able.
Grateful, would be grateful.
Because in any way it is not, no purposes will be fulfilled. Pending the matter without any investigation.
Nothing will be, this will be pending. Someday it will be dismissed for default. The officer will be in a problem.
Yes.
Learned advocate appearing for the petitioner has challenged the continuance of Forgery PS case number 800 of 2023, dated 7/11/2023. Wherein the case was initially registered under the relevant provisions of the Indian Penal Code, and subsequently AAE provision earns regarding relating to Prevention of Corruption Act 1988 has been added. Full stop. Learned advocate appearing for the petitioner submits that that there are no accusations in the FIR so far as the present petitioner is concerned, and the petitioner being the additional district sub-registrar. Additional additional district.
At that relevant point.
At the relevant additional district sub-registrar at the relevant end point of time. Discharge his duties in consonance with the provisions of law, adhering to the rules, and in spite of the same, she has been implicated in connection with the instant case. Also, Mr. Georgie A. Chaudhary A. Lane and additional advocate AG, appearing on behalf of the state, submit that pursuant to certain directions passed by the Honorable High Court in a proceeding under Section 438 of the Code of Criminal Procedure, the petitioner was brought within the ambit of investigation. Subsequently, the petitioner approached the court in the present revisional application and কি বললাম? And by an order dated 19/2/2025, a coordinate bench was pleased to stay the proceedings of Puj Bihar PS case number 800 of 2023, dated 7/11/2023. Mr. Chaudhary E. Learned AAG submits that the investigation of the case was under progress, but since it has been installed, the investigating agency is unable to unearth the truth. Full stop. Having in regard to the peculiar facts and circumstances of the case, particularly with regard to the letter of complaint, which was addressed to the concerned officer, and the FIR being registered, and the subsequent orders being passed, wherein the petitioner was brought within the ambit of investigation. I direct that no coercive steps be taken in against the petitioner until and unless the investigating agency finds it impossible to proceed with the next stage of the case. Full stop. In case such an incumbency arise, the permission be sought for from the learning aid special court or the learning aid learned special court or the learned ACJM in CCN of the case. As the petitioner happens to be a government servant who is regularly available in the office, and there is no scope from fleeing away or evading the process of law. Petitioner, on the other hand, is directed to cooperate with the investigation of the case so that the investigation of the case can be taken to its logical conclusion. I am of the opinion that at this stage, the investigation cannot be scuttled since the initial FIR makes out a case. Full stop. So far as the complicity of the present petitioner is concerned, the same is to be assessed by the investigating agency in course of progressing with the investigation of the case. However, the investigating agency will keep in mind, therefore, say a direct. So far as liberty of the present petitioner is concerned. With therefore say 8 observations. CRR 84 of 2025 is disposed of pending applications. The winnings continue to dispose of several copies. But one in this one stay maybe with the interim order of the interim order of any is here by but grateful. You are protected, sir. Let the investigation go on. Otherwise, this will
Yes,
lie
ma'am.
like this.
Yes, ma'am. I'll cooperate with the investigation.
Grateful, Lord.
Keep your blessed, ma'am.
Who is your other side? 19 order, the interim order earlier granted aid is extended till 31st of July 2025. List the revisional application before the next available circuit aid bench. Accordingly, is a CRAN is there? No CRAN. আচ্ছা ঠিক আছে ও to the এই করো না to the office to the where is the address which Inata so your investigating officer will go and serve, sir. Go and serve at his home. The investigating officer of the case or any officer of the CBI would effect service on the opposite party. How many? On the opposite aid party at the address indicated in the cost title of the application. Serve a copies. Very much. Thanks. Yes. Ma'am. Yes. Yes.
My lord.
চার্জশিট হয়ে গেছে কি আছে?
With your de facto complaint.
Oh, my lord. My lord, Sandeep sir, for the de facto complainant who is supposed to be appear virtually, but due to some technical issue,
that time নিচ্ছে একবার টেকনিক্যাল ইস্যু বলছে একবার
my lord, as per them.
সন্দীপ মন্ডল
Shandip Mandal.
এই এদিক ওদিক দুটোই তো এই সন্দীপ মন্ডল ও সন্দীপ মন্ডল চাইছে ও সন্দীপ মন্ডল চাইছে হ্যাঁ টেপ মারতে সবাই চলে গেল আর এখানে শরীর খারাপ করলো settle how in what terms তা এতটা কাজ করলে কি আমাদের পুলিশ কি হবে তাহলে কি আছে So these are where is the joint compromise petition?
Nothing filed. I have not received any copy.
তাহলে কোথায় এই একটা করে টাকা দিয়েছে এইসব কি করে এখানে কিষেন রায় তো অনেকদিন ধরে পড়ে আছে
There is a compromise, my lord, send it back to trial court. In terms of the compromise, they'll dispose it off.
Just have a copy of the কি ম্যাটার এসব আজে বাজে সেকশন ট্রায়াল কোর্টে আবার পাঠাবো ইউ গেট আ স্টেটমেন্ট রেকর্ডেড অফ দ্য কমপ্লেনেন্ট হু ক্যান হি উইল হ্যাভ টু ডু বিশ্বাসকে করতে হবে উইচ পুলিশ স্টেশন জয়েন্ট কম্প্রোমাইজ অনেক দিন তাহলে নেক্সট সার্কিটে চলে যাবে ছেড়ে দেবো ইউ গেট ভক্তিনগর আইসি ভক্তিনগর উইল এনগেজ এন অফিসার টু রেকর্ড দ্য স্টেটমেন্ট অফ দ্য ডিফেক্ট কমপ্লেন
One line order.
হ্যাঁ করে দেবো ইউ আর রিটেনিং দ্য কেস ডায়েরি না
Yes.
Learned advocate, you are also saying compromise has been done. Learned advocate aid for the petitioner as also the private opposite. পরের দিন দেখবো হবে কি হবে না পরের দিন দেখবো but let them file learned advocate for the petitioner and the private opposite aid party number 2 submits that pursuant to the charge sheet having been submitted, the petitioner and the opposite party number 2 have settled the dispute and differences, and the de facto complaint do not intend to pursue with the criminal case. Although the-
one has appeared before your law, approached you before this court. There are two charge sheeted accusations. One has not approached.
if the de facto complaint withdraws, তো সবাইরই হয়ে যাবে।
I just pointed out.
Cannot be, piecemeal compromise is never
It's
there,
not
sir.
once.
The criminal case, settled by Supreme Court of CRPF Finance Limited, C8 Financial Services Limited. Piecemeal compromise is not allowed. কি বললাম? In view of the aforesaid, Mr. Biswas appearing for the state will communicate with the inspector in charge of the Bhaktinagar Police Station who deputed a sub-inspector of his choice for recording the statement end of the de facto complainant in respect of the submissions advanced before this court. ঠিক আছে? কবে বৃহস্পতিবার হবে না পরে স্যার কি?
Or second, exactly. Matter 20th, only one matter 20th.
আর রাখবো না কিন্তু 20th, লাস্ট এটাই একটাই থাকবে। It's the that one I have disposed it of, sir.
There was a very important matter, my lord, with regards to Alipurduar.
List the on this revision application on 20th February 20 June 2025, when the revision application will appear under the heading to be mentioned. A report be submitted along with the statement. Two things you will do. You tell your officers, I do this at Calcutta because everybody must be safe. You must be safe. Your officer must be safe. This would be, a statement would be recorded and a declaration should be taken.
A separate declaration, my lord, or?
Are separate. The de facto complaint will write a letter to the inspector in charge.
Lodge.
That he or she intends to withdraw the case, and there will be an official acknowledgement to that effect. And the identification also with the voter's identity card and everything.
Lodge.
আজকাল যা দিন তারা আজকে বলছে করেছি কারো বলছে সরকারি কর্মচারী আবার ও
We can produce the de facto complaint as well.
No, that is not my business actually. কি বললাম? Report be submitted along with the statement and declaration of the de facto complaint. Well, sorry, official fix.
For the petitioners in item number 74, lordship.
Yes.
My lord, this was heard earlier, my lord. Thing is that at that time the some pagination was not there in the CD.
Acha.
Now I have brought the CD with the paginations, my lord. 3 statements are there, my lord. I think these are. There is the
My lord,
Under
may I-
section?
306.
306 of IPC, lordship. May I? Here the,
Tomorrow, আর ভালো লাগবে না। Dictation দিতে হবে, ওইটা just give me the CD.
They are the father and mother of the principal accused.
I will just go through the case diary, I don't remember. Tomorrow I'll take your matter, sir. মামলা কমানি, এতগুলো করে মামলা করলে এখন 4টার সময় মাথায় কিছু থাকে, আর কি হয়ে যাবে, অর্ডার হয়ে যাবে, তা মুশকিলে পড়বে। আজকে আর বেশি অ্যাড করবেন নাকি? এটা কি আছে? Any urgent matter, sir? Then I'll start. I've got a dictation to do also.
My lord, restoration application of PWD. A restoration application, item number 76, my lord. My
Where
lord,
is the application?
Yes, my lord.
There was a report I need to submit regarding the service upon the de facto lodging. Kindly give me 1 day's time. I will submit.
The same condition in CO, in court number 1 with regard to CO. They could not, they are not receiving.
Actually, my lord, they have been going to their places, but they have not, they are not there, my lord.
Okay, tomorrow I'll consider.
My lord, kindly give me not,
Let the list be there, sir. Tomorrow, I'm not calling any of the matters. Tomorrow I'll.
Not keep it on Thursday and Friday, but because.
Only tomorrow.
Lordship, I have small indulgence, Lordship. In item number 59, Lordship had directed to matter to fixed before the next available circuit bench, but I need stay, Lordship. Because Lordship,
সবাই চায়।
Lordship, the
Needs-
matter is regarding, we are praying for transfer.
No.
Lordship,
ট্রান্সফারে
Only 1 day's accommodation, lordship. Right.
এই ফাইলটা কোথায় দাও ডিক্টেশন তেমন করে আর দুজনকে রাখো এ কোথায় গেল আইটেম নাম্বার ওইটা দিয়ে 6 নম্বর আইটেমটা দিন ঠিক হ্যাঁ বড় আছে কোথায় গেল তোমার একা হবে না তুমি তিনটে 10 12 14 কোনো কথা হবে না The present divisional application has been preferred, challenging the proceedings. Relating to GR case number 6842 of 2022, arising out of Kotwali Police Station case number 845 of 2022, dated 10th December 2022, which was registered for investigation under section 305/34 of the Indian Penal Code. You are in this matter? Yeah. Okay. Achha. The next paragraph, the petitioner before is court happens to be one Sutopa Das. The headmistress is of Suniti Bala Shodar Girls School.
Shodorgal.
সদর না সদর গার্লস আর হবে না এখানে ভুল আছে SADAR সদর গার্লস স্কুল formerly known as ব্র্যাকেট দাও formerly known as সদর গার্লস স্কুল গেল নেক্সট প্যারাগ্রাফ চলে যাও the allegations made in the written complaint which were asserted to be the first information report of the instant case was at the behest of one Devdulal Ghosh, who addressed a complaint to the inspector in charge, Kotwali Police Station, alleging that his daughter was a student of class 8 of Jalpaiguri Shodor Balika Vidyaloy. Full stop. On or about December 7, 2022, during the examination, a student named Anonna, sitting behind his daughter Shreya Ghosh, irritated her by querying in respect of certain questions. Full stop. As Shreya ignored her, the said Anonna along with 2/3 students after the examination was over complained to a teacher namely Chandani Mukherjee that Shreya adopted unfair means during the examination. Full stop. Based on such accusations, the complainant was asked to report to the school on December 8, 2022. Also, the headmistress and the teacher Chandani Mukherjee, without clarifying the incident, started humiliating the informant in front of his daughter. Full stop. The said teachers also threatened that the judgment format away. The said teachers also threatened that they have identified his daughter and would see how she passes next year. Full stop. When the complainant protested to urge wild accusations being made against his daughter, the headmistress and the teacher misbehaved with him and he was ousted from the school. Full stop. Complainant's daughter at the relevant point of time started crying, however, she was consoled after returning home. Full stop. After returning home, the 13-year-old Shreya became silent, stopped taking food, and on December 9, 2022, when she was alone, committed suicide by hanging herself from the fan with the aid of a nylon rope at her throat. Full stop. The complaint alleges that her daughter left a suicide note which reflected that she was mentally harassed and could not accept the humiliation of the teachers. Full stop. On the efforts, a complaint of Devdulal Ghosh, Kotwali Police Station initiated the investigation. Kotwali Police Station case number 845 of 2022 commenced, and the investigating agency, on conclusion of investigation, submitted a charge sheet against the present petitioner being the headmistress and the teacher namely Chandani Mukherjee. The prosecution, in order to prove its case, relied upon 20 witnesses and 8 documents. Full stop. Next paragraph. Learned advocate appearing for the petitioner submits that even if the accusations are accepted to be true, no case for abatement to commit suicide is made out against the petitioner, who is the headmistress of the school, whose sole purpose for admonishing a student would be welfare of the student of the child, and no ill motive can be attributed to her act or action. In order to substantiate his case, learned advocate relied upon the following judgments. Nitai Dotto versus State of West Bengal, 2005 to SCC 659. Geo Varghese versus State of Rajasthan Nada, 2021-19, SCCE 144. আচ্ছা, পরে ওগুলো ডিল করবো। Learned advocate appearing for the state oppose the prayer advanced on behalf of the petitioner and submitted that as the investigating agency, on conclusion of investigation has arrived at a prima facie conclusion, thereby making thereby charging the petitioner and another under section 305-34 of the Indian Penal Code, it would be unwise to scuttle the proceedings prior to a full-fledged trial having been concluded. Learned advocate 8 for the opposite 8 party, next paragraph, for the opposite 8 party number 2 submits that the suicide note which was left by the deceased accused the headmistress and the teacher, which points to their irresponsibility, and as such they should not be allowed to go scot-free without facing whole of the trial. Yeah, we need to go. I've considered the submissions advanced on behalf of the learned advocate appearing for the petitioner, state, as well as the de facto complainant. And on a consideration, and also the case diary produced on behalf of the state. I find that at this stage, what he is to be primarily considered by the court is as to whether the petitioner being the headmistress should be asked to pay the trial, or the case taken as a whole should be terminated at the stage on an overall assessment of the materials collected by the investigating agency. As the learned advocate appearing on behalf of the opposite party number 2 oblique de facto complaint as well as the state emphasize on the suicidal note, which is also part of the documents relied upon by the prosecution while submitting its report under section 173E of the CRPC. I am of the view that the same should be primarily should be considered peremptorily prior to arriving at a decision. Acha. The contents of the states reside note reflects that the deceased lamented that she was a victim of false accusation of cheating in her school, and she was unable to tolerate the same. Acha. Such accusations of cheating were only on the basis of the complaint of only one girl, and such was the situation that nobody was willing to accept her version. Acha. The parents also had been in consoling her, but she felt that there was some sort of suspicion in the mind of the parents, the friends, and the others with whom she was acquainted. Full stop. She also stated that she knew that her friends had full sympathy for her, but it was she who was unable to face them because of such information having spread. And there was no way out to prove herself to be innocent. As such, she explains that she was unable to fight against such odds and has decided to end terminate her life. Full stop. I have considered therefore also a suicidal note, along with the statement of the different witnesses is concerned. And I do not find that the headmistress or the teacher find its place in a manner which is against or exceeding the authority of a head of the institution or the duty of the teacher to be discharged. Acha. In Nitai Dotto, Supra, relied upon by the learned advocate appearing for the petitioner, the following observations of the Honorable Supreme Court are relevant. এখানে না এই 5 ডট ডট দিয়ে an offense থেকে আর 6 এই পর্যন্ত এনে দেবেন, ঠিক আছে? পেজ নাম্বার 40। হ্যাঁ, আচ্ছা। In Geo Varghese, supra as relied upon by the learned and advocate appearing for the petitioner. The Honorable Supreme Court referred to the suicide note in the said case at paragraph 39, wherein it was observed as follows. Para 39 টা page 54 এ আছে ওটাকে নিয়ে নেবেন। I've also taken into account the judgment of the Calcutta High Court in similar set of circumstances. In Mrs. D.A. McGilvery versus State. এটা একটা ফ্ল্যাগ করে দিন না, বড় ফ্ল্যাগ না হলে বুঝতে পারবেন এটা আলাদা পেয়ে যাবেন। Wherein a division bench reported in 1986 Calcutta Criminal Law Reporter Calcutta 233, wherein it was categorically observed that the principal of a school as an administrative head of the institution in relation to misconduct of a student of a school has to rise to the occasion and deal with the same. Full stop. In case a student is reprimanded or admonished, the same would fall within the duties of the head of the institution and will not amount to an instigation to commit suicide. Acha. The suicidal note নেই বেশি আর কাউকে নেবেন না গন্ডগোল হয়ে যাবে আর বেশি নেই আর the suicidal note in the instant case do not in any manner name the headmistress or the teacher or any role is also defined to attract any criminal liability to attract any culpability of abatement so that the headmistress can be asked to face the ordeal of a trial. Mere scolding a student cannot come up within the definition of abatement, as the same is the duty of a teacher while discharging his duty. Next paragraph. There may be pain of a parent of the parents. There may be pain of the parents after a child passes away, but to vent such grievance, to ventilate such grievance by way of implicating the headmistress and the teachers of the school without any foundation, without any factual foundation, would obviously result in travesty of justice. Having in regard to the settled propositions of law, particularly the factual circumstances under which the division bench of the Honorable High Court in similar set of circumstances came to the conclusion that no case under section 306 of the Indian Penal Code has been made out, and the charges in the said case were framed mechanically. I am of the view that on a consideration of all the all the materials collected by the prosecution, no charges so far are as abatement to commit suicide aid under section 305 or section 306 can be said to be made out against the present petitioner, who happens to be the headmistress of the school, namely ki
সুনীতিওয়ালা সাদর গার্ল স্কুল
সুনীতিওয়ালা সদর, একটু দেখে নেবেন ভাই এই প্যারাগ্রাফ নাম্বার। সুনীতিওয়ালা সদর গার্লস হাই স্কুলের সর্দার আছে, হ্যাঁ সদর হবে, সদর গার্লস স্কুল, হাই স্কুল না স্কুল। Consequently, all further proceedings pending against the petitioner arising out of Kotwali Police Station case number 845 of 2022, dated 8 December 2022, corresponding to GR case number 6842 of 2022, is hereby quashed. The revisional application being CRR number 254 of 2024 is allowed. Pending application, if any, is on the disposal of several copies. I'll give you the case diary later on. I'm keeping the hand. Huh? No, but this is off. This matter is off. So just take it tomorrow from my court officer after they complete. Huh? Otherwise, they're requiring. খালি লিখে দেবে কেস ডায়েরি বি রিটার্ন টু দ্য লন্ডন অ্যাডভোকেট অ্যাপিয়ারিং। এটা একটা কাউকে ডেকে আমি যাওয়ার আগে দিয়ে দেবে, হ্যাঁ রেকর্ডটা রেকর্ড রুমে চলে যাবে।